And we'll get you sworn in at one time, if you can hear me. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth? And that would be yes with a nodding of the head, I think. Yes, okay. All right, then we got that done. We're just trying to get things out of the way. We generally have a lot of cases, and do we have a private lawyer who's going to want to be moved up?
Yes, Your Honor. Joseph Flynn. I'm here on Nelson Collazo, domestic violence case.
Okay. Oh, you want me to start with that? Okay, we're going to start with that one then, counsel. Okay. All right, Mr. Collazo, we have your lawyer here. He's just getting ready to come up.
Apologize, Your Honor.
And it was an alleged, do we have a witness?
Yes.
All right.
Brianne Garcia, Your Honor, should be in there.
An alleged, okay, there's an updated. Domestic battery and alleged written threats to kill. You just got sworn in, ma'am, correct?
Yes, ma'am.
Okay. Sorry, it's case number 21 CF 6056, going to Division 14. And it's like they had enough information to at least file it. But ma'am, state's going to want to ask you some questions about safety, whether you want contact or not, what conditions, if any, make it safe, things like that.
May I, Your Honor?
Yes, ma'am.
Good morning. Can you please tell the court your name for the record?
Brianne Garcia.
Okay. And what is your relationship to Mr. Collazo?
He's my fiance.
Okay. Approximately how long have you known him?
8 years.
Okay. Are you afraid of him?
No,
Has anything like this ever happened before?
no, not like this, no.
If anything ever like this happened in the future, would you feel comfortable calling 911?
Yes,
Do you believe drugs or alcohol were involved in this incident?
yes.
Can you tell the court which one?
It was alcohol.
Okay. And do you want to have contact with Mr. Collazo?
Yes, that's fine.
That's all I have, Your Honor.
All right, ma'am, he's got some history, some criminal history. Are you aware of it?
Yes, ma'am.
Include sexual battery and domestic violence arrest?
Yes, ma'am. I'm aware.
Yes or no?
Yes, I'm aware.
Okay. Do you need any additional conditions, or you just want him released and to have him told no hostile contact?
Yes, that's fine. Just release and no hostile contact.
Okay. All right. Anything else?
Your Honor, we would ask that a bond be set at a reasonable price. Mr. Collazo does work small jobs here and there right now. He does have the means to afford a bond, but we'd ask to keep it low. I know the court has notated his history. I would put for the record, the sexual battery case was when he was very young, and it involved a girlfriend who was underage that he was in a relationship with. He did plead to it and did do time in Department of Corrections. The court also noted other domestic violence cases. Those are pretty old from what I reviewed, at least. I don't have the entirety of the NCIC like the court does, and they were dismissed. I don't believe, if not inquiring of the witness, I don't believe that Ms. Garcia was the victim in those matters by any means.
Well, I don't have the entire NCIC, but I have notes that are compiled by the BRC staff. And all right, well, given the circumstances, did the state want to say anything, the regular conditions?
Your Honor, even given the victim's testimony here today, state would still ask for no contact. The allegations in the affidavit are rather violent. The threats made are also very violent. And I do fear for the victim's safety, even giving her testimony here today that she's not afraid. Also taking into account the defendant's history. This isn't his first violent offense or even his first DV battery. I know you already notated for the record some of his history. So for all those reasons, I would ask for still a no contact order with the victim. However, Mr. Colazo is entitled to bond, so I just ask that you set a bond that is in conjunction with his history and the facts in this given case.
All right, a lot of things go through my mind. I totally understand what the state's saying. As far as the witness, ma'am, oftentimes it'll take you about 6 times before you finally give up and decide that it's not going to change. I'm not saying that's for sure, but I've been doing this for over 40 years now. So I notice what the patterns are, and I give a high degree of deference to what she's saying, even though I'm just saying, ma'am, he has got a real temper. You're not completely out of danger. I'm going to acquiesce to your wishes at this time and say no hostile contact. If you have any guns, knives, or weapons, put those in the care custody of the arresting officer within 24 hours of your release. State's generally requesting no alcohol while you're out on bond when that's a factor. And I'm tempted to really hike up the bond because of your history. I'm very concerned about you, and I don't want to do anything to make you think that this is minimal. It's not. But because I know that she's going to pay the bond, I'll put it at 2,000 instead of 5, which was my normal actual reaction to the allegations.
Thank you.
Good luck.
Thank you, Your Honor. There's 2 counts. You're putting 2,000 on count 1?
Oh, yeah, so that was on the, I'm sorry, the threats, the written threats, and 500 on the battery, although that was extensive as well. I'm sorry, 100 because it's a subsidiary charge. Yes, I'm sorry. Thank you, good luck.
Thank you.
Okay, are we back, are we at the resets now? Or another wit? Oh, interpreters, okay. All right, and are those? Yes. Okay. And this is everything. Okay, got it, thank you. All right, yes.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you very much. Our first case this morning is Ms. Elsie Colazo, and the case number is 21 MM3501. Thank you. And we have a witness who has been previously sworn, is that correct?
Yes, ma'am.
Okay. Now, the witness also prefers Spanish.
Yes, please.
If the interpreter wouldn't mind, we could take the earphones off of Ms. Colazo so that both the witness and the defendant need to hear the interpreter. Could we take those off? Thank you. All right, thank you. In this case, it's alleged that the 2 of you are sisters and there was some pushing and shoving and biting and maybe hair pulling. Would the sister state
En
her
este caso,
name for the record? Thank you.
en este caso se alega que aparentemente ustedes son hermanas, hubo un problema, se empujaron, aparentemente también se alaron el pelo. Señora, la testigo, por favor, diga su nombre para que conste en actas.
Elismari Collazo.
Elismari Collazo.
Thank you. Ma'am, do you want contact when your sister gets out of jail?
¿Usted desea tener contacto con su hermana cuando ella salga de la cárcel?
No contacto, por favor.
No contact, please.
Okay. Do you live at the same residence normally?
¿Ustedes usualmente viven en la misma casa?
No.
No.
All right. Anything else?
¿Algo más?
Yo no quisiera contacto ni conmigo ni con mis hijas, que ella se mantenga distanciada.
I don't want any contact neither with me nor my daughters. I want her to stay apart.
Your Honor, I do believe there's a non-expiring injunction in place between.
Su señoría, tengo entendido que hay una orden de alejamiento en vigor.
Sí, de hace muchos años, es correcto.
Yes, from many years ago.
Okay. There's no additional charge in relation to that at the moment, though, State?
No, Your Honor, I'll just bring it to your attention due to the victim wanting no contact.
Okay.
No hay acusación adicional al respecto en estos momentos. No, su señoría, meramente se lo traigo a su atención porque la víctima no desea tener contacto.
Okay. All right, I don't know if the state has some questions. That's all the questions I had.
No sé si la fiscalía tenga alguna pregunta, esas eran todas las preguntas que yo tenía.
Briefly, Your Honor, are you afraid of Ms. Collazo?
Señora, ¿usted le teme a la señora Collazo?
Ya a este punto sí, porque ella es muy agresiva, demasiado agresiva.
Yes, because she is very aggressive, too aggressive.
Okay, and has anything like this ever happened before?
Algo similar a esto ha ocurrido en el pasado.
Es correcto.
That is correct.
And do you believe drugs or alcohol were involved in this incident?
¿Usted considera que en este incidente tuvieron que ver las drogas o el alcohol?
Ella es usuaria, yo no sé exactamente lo que ella usa y no sé si ella estaba drogada en ese momento, pero ella es usuaria.
She is a drug user. I don't know exactly. She's a drug user. I don't know exactly what drug she does, and I don't know if she was under the influence at that time.
Okay, thank you. That's all I have, Your Honor.
Okay, thank you very much.
Yeah.
Yes, ma'am.
Your Honor, she does qualify for pretrial release. I would just ask for pretrial release based on the conviction history. It shows a list of, for the most part, nonviolent offenses. So I'd ask for straight pretrial release.
Su señoría, estamos solicitando que se le conceda la libertad provisional tomando en consideración sus antecedentes, que en la mayoría son asuntos que no son violentos.
Your Honor, I understand that she otherwise qualifies, but given the victim's testimony here today, state would object. They do have a pretty violent history between the two of them. There is an injunction in place. And even though the alleged battery in this case, it looks like a pushing and pulling of the hair, it seems to be an unprovoked attack. So for those reasons, state would object to PTR, but if you are inclined to put her on PTR, I'd ask for bond in conjunction with PTR.
Su señoría, a pesar de que entendemos que ella cumple con los requisitos para que se le ponga en libertad a través del programa de libertad provisional, nosotros estamos solicitando que no se haga por el historial violento entre la acusada y la víctima, aunque este caso meramente se alega que el incidente de agresión fue que se empujó y que le aló el pelo, pero aparentemente fue sin ningún tipo de provocación, además del hecho de que hay una orden de alejamiento en vigor. Si su señoría está inclinada a concederle la libertad provisional, pues le solicitamos que sea bajo fianza y supervisión del programa de libertad provisional.
I'd like to ask the witness, ma'am, I noticed that your sister's on disability income. If she is told to stay away, do you feel like that will be enough to ensure your security?
Señora testigo, quiero hacerle una pregunta. Yo he notado que su hermana está recibiendo ingreso por incapacidad. Le pregunto, si nosotros le ordenamos a ella que se mantenga alejada de usted, ¿usted piensa que esto es suficiente para mantener su seguridad?
Pues la realidad no sé, aparte de los empujones que se hablaron y de los jalones de pelos, hay un injury en mi dedo, está fracturado debido a que ella me mordió y la mordida provocó que el dedo está roto. Yo no pude traer pruebas porque no me permitieron traer papeles, pero yo me tuve que ir a atender médicamente y, o sea, no es un jalón de pelo, no es una empujada, ella es agresiva.
Maybe to your
Your
lawyer
Honor,
is
the
safe.
truth is that I don't know. Even though they're saying here it was just that she pushed me and she pulled my hair, she also bit me and broke my finger because of that bite. I didn't bring any proof here today because they told me that I couldn't bring any documents, but I had to go to the hospital and receive medical attention.
Okay, so you think she should post bond in addition to pretrial release?
Así que entonces, señora, ¿usted considera que ella debería prestar una fianza además de la supervisión de la libertad provisional?
Sí, y si fuera posible que le dieran ayuda por su comportamiento, yo pienso que ella necesita ayuda profesional.
Yes, and also I would like to request that she'd be given help because of her behavior. I think she needs professional help.
Okay, well, I also noticed there might be a mental health background, and possibly we could screen her for mental health pretrial release, but I don't know if a battery qualifies for that.
You can have her screened, Your Honor.
Yo he notado que ella tiene historial de salud mental, así que yo creo que a lo mejor podría evaluarse para ver si puede ser vigilada a través del sistema de libertad provisional por salud mental. No sé si cumpla con los requisitos.
We don't have as much help as I would like to offer you. Florida's about 49th in the nation as far as providing those services.
Pero nosotros no tenemos disponible la ayuda que yo quisiera ofrecerle a usted.
Thank you.
Gracias a usted.
Your Honor, we would just ask for pretrial release. I know mental health pretrial release can take a couple of days, and due to a death in the family, that she wishes to attend the funeral, I would just ask that she be released on pretrial release.
Su señoría, nosotros estamos solicitando que se le conceda la libertad provisional, ya que ha habido una muerte en la familia y ella desea estar presente.
All right, my condolence to both of you for the loss of your uncle.
Le ofrezco mis condolencias a ambas por la pérdida de su tía.
Gracias.
Thank you.
I can't make this situation perfect.
No puedo hacer que esta situación sea perfecta.
Let me give you an alternative.
Déjenme ofrecerles una alternativa.
We'll start the screening for mental health pretrial release if eligible.
Vamos a comenzar haciéndole la evaluación para que se apuesta en libertad provisional bajo supervisión de salud mental, si es que cumple con los requisitos.
If that takes too long, the alternative is a bond of $1,000 plus pretrial release.
Si eso fuese a tomar mucho tiempo, entonces la alternativa es que preste una fianza de $1,000 bajo supervisión del régimen de libertad provisional.
No contact with your sister or her kids.
Se le prohíbe el contacto con su hermana y sus hijos.
That's complicated by your uncle's funeral. I don't have good advice about that, except it might be a problem for you to attend.
Eso podría traer una situación en el funeral de su tío. Yo no tengo consejo que darle, pero es probable que usted no pueda presentarse allí.
If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release.
Si usted es dueña de pistolas, armas de fuego o cuchillos, tendrá que ponerlas bajo el cuidado o entregárselas a las autoridades a las 24 horas de ser puesta en libertad.
If you do qualify for mental health pretrial release, Ms. Colazo, I highly recommend it. I've seen some lives changed with that process. Good luck to you.
Señora Collazo, si usted cumple con los requisitos de la libertad provisional a través de salud mental, yo se los recomiendo. Yo he visto muchas vidas cambiar a través de ese programa.
Your Honor, state would also ask for a no return to the victim's residence.
Su señoría, también estamos solicitando que se le prohíba regresar a la residencia de la víctima.
Thank you, counsel. So ordered.
Gracias, licenciada. Así se ordena.
Thank you.
Gracias.
You're welcome. Okay. This is Mr. Bonilla Rodriguez. And it's case number 21 CT 37151. I'm sorry, 3751. And so the allegation is driving without a license.
Yes.
Evidently, they have enough information to file the charge.
Your Honor, state conveyed an offer of a withhold and evidence.
Okay.
Your Honor, I would ask for release, but a ROR, it's a non-violent offense. And something has no criminal history. I'm not sure of his immigration status as well, Your Honor. So I would just ask that he's given an ROR.
Okay, so, you could qualify for the public defender services if you wish. And, you don't have any prior history that we know of here in the United States. The public defender is concerned about you, getting legal advice before you accept the charge, because any criminal charge can result in deportation if you're not an American citizen, and or authorized to be here. Alternatively, the prosecutor recommends a sentence of time served. No actual conviction, but it does show up on your record that you had this charge, which is a crime. And court costs are imposed, which are in the area of $300. It's probably a little more, but we give you time to pay that, which you would want to pay attention to, because non-payment of fines results in a suspension on your ability to get a license, and if you get caught driving after that, it's a bigger crime. So you could resolve it, or, so is the reason he's not qualified for pretrial release because he did not get interviewed, or?
Yeah, he refused. What the representative stated, he refused to talk with us,
Right,
so we can.
you couldn't qualify him. Pretrial release is a non-monetary form of release. And if you did get released, you need to come back to court. So if you don't plead out, I would authorize either a $500 bond or pretrial release if eligible. You might have to talk to him to get interviewed again in regard to whether or not you have sufficient local ties to make it reasonable to assume that you will come back to court. So there's all opportunities to get out of jail by interviewed and giving them information about, you know, I guess you might be scared to tell them where you live because you're worried about immigration also, but it's a way to get out without post bond. And then also, if you want a time served plea, that's okay. So you have those options. Do you have enough information to make a decision today about whether you want to get out a posted bond or a pretrial release, or if you want to accept the charge and accept the time served sentence?
Quiero pagar la fianza. Quiero pagar la fianza.
I would like to pay the bond.
Okay then, sir. After you pay the bond, they will give you the court date and time to come back to answer the case. Once you bond out, it's not over. You still have to come to court. Good luck to you, sir. Yeah, if he qualifies, yeah. Right, okay, thank you. Is this Mr. Miranda Gomez? All right, here we have. We have a new charge, 21CT3752, of driving without a license while out on bond. Driving a license suspended, in case number 21CT138W, and that would be a bond of $500. Sir, when you have a new criminal charge, when you're out on bond, another criminal charge, it's a violation of your release conditions, so take that into consideration. And you definitely qualify for the offender with 5 dependents.
Sí, por favor.
Yes, please.
All right, sir, interesting. Looks like it was way in the middle of the morning. All right, sir, and I don't have actually your whole, wait a minute, I do have your driving history. Sir, I don't know if you want to try to resolve one of these cases. Maybe the state does not want to because, number one, you got a couple things going on at one time. Number two, it appears from your driving record that you're trying to pay some fines. And maybe that's what you're doing with the outstanding driving while license suspended case. Maybe you're trying. I don't know if you could qualify in terms of your citizenship status or not, but if you keep getting driving while license suspended cases and you get 3 within 5 years, then you get a 5-year suspension on your license, and any following driving is a felony. I'm tempted to guess that you were on your way to work because it was 5 o'clock in the morning when you supposedly passed out at the wheel, and they did not charge you with a DUI, so it's just interesting. Got a lot of dependents too. So if and I don't know that we could resolve them all today or not, even if you wanted to. I'm tempted to point to public defender.
Your Honor, I did convey an offer of an adjudication of guilt that can be served on both his new law and new valid and the out on bond cause.
Your Honor, I would just ask that you set a bond amount in this case. He is working to try to get his license back. I don't want him to rack up a ton of driving while licenses suspended. And also, I am not sure of his immigration status. I would just ask that you set a bond amount.
Oh, wait, it says U.S. citizen on his driving record.
I didn't have it.
I mean, are you okay as far as immigration? Maybe he's afraid to answer, I don't know. But, did you talk to him, or are you,
That's why I would just ask that you set a bond.
okay, all right, okay. Sir, the prosecutor's offering you time served on both, and convictions. But as I told you, you get 2 or 3 of these things and you upgrade yourself into felony court, and it looks like you're getting close if you're not going to be already there. The new charge is actually written as a no valid, and so if you're trying to avoid a conviction for that, that's not yet a driving license suspended case, although the state could upgrade it if we get further down the line. If you're trying to get your license straight, then the public defender's advice is correct. You should bond out and keep working on your license. Alternatively, the state's recommended time served. If that's more convenient for you than coming back to court and you don't mind racking up convictions, that's an opportunity for you. So you have a choice. Do you understand what that choice is?
Quisiera pagar la fianza.
I would like to pay the bond.
Okay. All right, sir. And I see that you, it looks like, I bet you do have 5 dependents. All right.
Yes.
All right, we're appointing the public defender. You're gonna get 2 court dates when you first get out, because when they first start out, they have different court dates. On the no valid license, the new charge, the bond will be stayed at 500. And on the other one that you were out on bond, so, sir, I would double the bond amount to 1,000. Normally, it would be more because of the, new law violation, but I'm just concerned. You have a lot of kids, and you might have actually been so tired you fell asleep while you were driving. Right. If you can try to get your license back, make sure you attend all your court dates, sir. When you have more than one case, that could get confusing.
So you're in your book, the out on bond, and made it 1,000?
Right, I just doubled it to 1,000.
Esa señoría,
Right, make sure you come back to your court dates.
no, le hago una pregunta.
Your Honor, may I ask you something?
Yes, but don't say anything about the case, the facts of the case, because you might accidentally admit something.
Yo pagaría 1,500 para poder salir hoy de acá. O
So then I would have to pay $1,500 for me to be able to get out of here today.
Oh, I see, your first one might have been cash bond, so what you might want to go to a bondsman at this point and start talking about a percentage payment with collateral. That's what most people do.
ok. Está bien, voy a ir. Entonces, a ver. Sí, quería trabajar, no más que mis hijos están en la casa. Sí, iba para el trabajo. Ayer cuando había trabajado 2 días antes bastante y me quedé dormido en el volante. No, cuando llegó el judicial, me dijo que estaba durmiendo, sí, es cierto, estaba durmiendo.
Yes, then I will go and I will do that. Yes, I have to get home. My children are there. And yes, I fell asleep at the wheel yesterday. The day before, I had to work a lot. And I fell asleep. When the policeman came, he found me sleeping.
Right. If it was something else, he would have arrested you for DUI, sir. But, sir, you do need to get that license cleared up. It's a priority. Good luck to you, sir. Okay, Mr. Perez. Thank you, sir. This is case number 21CT874AW. They have probable cause for a charge of DI. It's relatively high breath result, sir. And you probably need the public defender to represent you on that. We'll appoint their office to represent you. And evidently you were out on bond, DUI, and a no valid license, so. I guess we'll stay the bond on the new one at 500.
Está bien.
Revoke and reset bond on the old one. That is 21CT. $700 AW. Instead of a $500 bond, it'd be $2,000. And on the no valid, 21CT 699 AW, revoke and double it to 200. The state's gonna want me to tell you not to drink alcohol while you're out on bond. And I think that goes without saying. If you're having a lot of trouble with that, the kind of thing that I would be thinking about, if it came back to me for sentencing, would be, sometimes I tell people, you could do 90 days of jail straight or 90 days of Alcoholics Anonymous straight. I'm just telling you up front. I'm not going to be your judge, but when I get people who have this high of a blow and they're out on bond, it's obvious you have a very significant alcohol problem, which is probably going to wreck your liver, your brain at a young age. But it's also true that you're dangerous on the road. And so if you want to start going every day to Alcoholics Anonymous, you really have to be able to offer that up to the judge as proof that you need to do some significant jail time in order to dry out. Number one. Number two, if anybody can help you get this addiction off your back, it would be them. We're appointing the public defender. I suggest you take it very seriously. You're at the point of likely jail time. In addition to wrecking your head. Good luck.
Una abogada particular.
May I speak to an attorney?
Yes, we're appointing the public defender, and we're giving you their address and phone number that you could call, hopefully, as soon as possible, so that you could make an appointment, because you do actually really need some legal help at this point, in addition to alcohol counseling. We wish you good luck, sir. Okay. Oh, really? What about Santos? Oh, okay, thank you so much. This is the one that bonded. Thank you. All right, for our interpreter, thank you so much this morning.
Thank you, Your Honor.
Okay, so we're back to. Oh, we haven't done the move up yet. Oh, jeez. Okay. All right, but we did most of the traffic. Oh, no, I'm okay with this. I just forgot. We didn't even touch the move ups. So
that's everything in order already.
got it, okay. All right, then. Is this Mr. Chester Scott?
Behavior.
All right. Now, knowing that the lawyers during the week prefer, he,
Your Honor, he was behavior on Sunday as well.
right, it's 21 MM 3478, and, what was this? Was it was a trespass after warning, while he was out on bond for a similar charge. Let's go ahead and appoint the public defender on this. And he's got some history. So I was willing to set the bond at 500, find a probable cause on the trespass, tell him not to go back to that Shell station, and just say no on the alcohol according to the state's recommendations generally. And in regard to the case that he's out on ROR for, it wasn't necessarily if it was a 33-day motion, it subsequently got filed, and he has a pretrial date, counsel, on the 24th of June, although he didn't grace the court with his appearance at arraignment. The public defender waived his appearance, and that is case number 21 MM 141980 in front of Judge Evelyn Jewett. So let's, on that one, revoke the ROR and give him a bond of 1,000 and tell him not to go back to wherever he was trespassed from on that particular case also.
On that one, it was the Quality Inn, Your Honor.
Okay,
Is it 500 on each count, Your Honor?
We only filed the trespass.
oh, on the old one?
We didn't file the false alarm of fire.
Okay. Thanks for that clarification. All right, we had a Simpson on the list, but Ship is the next file here. Okay, well, what about these other resets?
Those are the move-up cases that you're doing right now, so they're pulled out of order.
Well, okay,
These cases are the ones that they moved up, so they're from different sections in the docket.
oh, sorry, I've got this other list, I have Simpson.
Yeah, that's the reset section, so that's after the move-up.
Oh, that's after the move
Yes, we
ups.
pulled these out of order.
All right, okay, let me see where, okay, these are, okay, so we're on, I'm sorry. Still getting used to the. Okay, so Denarian Ship is here, not? All right, so that was a misdemeanor domestic. And we can appoint the public defender to represent Mr. Ship.
Your Honor, I'll waive the appearance.
Okay, that would have been in felonies, I guess, because he has also felony probation. So we'll appoint public defender on the new misdemeanor, which is case number 21 MM 3507. Fine PC for assault in regard to his mother, with some serious threats to kill. And she wants no contact. She wants separate residence, one-time police escort to get his things out of the residence. No weapons. Those would be put into the custody of law enforcement within 24 hours, if any release. I didn't see any on view for VOP for the felony probation. I don't even know if it's,
There is one, Your Honor.
there is?
Yes.
Okay.
I believe it is 18 CF 6418.
We don't have paperwork, but the jail might have a hold on him, but the paperwork's not filed yet. So I don't, the question
Want
was
me to print it?
Yes, what's the case number one more time?
18 CF 418, is that it?
I think it's 18 CF 6418.
6418, according to
Believe
the
so.
state? Different.
Miguel Gutierrez, 2018 CF 6418.
She's looking. Yeah, we didn't have any paperwork on the VOP.
We've
Just-
seen it listed on there, and when we called downstairs, they said it was an interstate compact case.
That's what I'm looking to see.
Okay, thank you.
It's the interstate.
Interstate, so it's not local. And they haven't filed anything.
I'm sorry?
And they haven't filed anything to detain him.
Yeah, it's on view on him. But we can't IA it because it's interstate compact.
All right, so he's being detained anyway, is what you're telling me?
Yes, Your Honor.
All right, so I don't have to worry about that. Okay. All right, so that's it for now. Public defender's appointed. Thank you. Oh, I'm sorry. I didn't tell you?
No.
All right. Well, given that he's got a history, he's on active felony probation for robbery and threats to kill, let's put it at 2,500 on the misdemeanor. Thank you. All right. So, let's see where we're at. Is this Mr. Mosry?
Yes, ma'am.
Okay,
Yes, Your Honor.
thank you. This is case number 21MM2957. And is this an arraignment? I'm getting used. I'm getting used to the paperwork again. Okay. So Mr. Mosry's been in jail for 23 days on a trespass charge in Division 84.
Yes, Your Honor. There is an offer of an adjudication of guilt, credit time served, and no return to the courtyard by Marriott at 730 North Magnolia. Court cost and cost of investigation of $101.32 to Orlando Police Department. I did speak to my client, and he would like to accept the state's offer here today and enter a plea of no contest.
Okay. All right, then, sir, you would raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. So, not going to have a factual basis in front of me, counsel. Does the lawyers, do the lawyers stipulate?
Yes, Your Honor.
Basis for purposes of a plea, okay. Sir, do you understand that you would be giving up the rights listed on your plea form?
I do, ma'am. Yes. Yes, Your Honor, I do.
Okay, so you won't have a trial, you won't have a jury of 6 people told that they have to have proof beyond a reasonable doubt as to every element of the charge before you can be found guilty, understood?
Yes, Your Honor, understood. It would be a waste of time, in my opinion,
Okay,
and money, both of which are precious.
okay. We do have a few trials stacked up after the COVID shutdown. But you've seen the form before and you understand the rights?
I do, yes. I was given an old copy of the form that is the same, I understand.
Right.
I will just say, this Marriott Bonvoy, there are 3 in the same vicinity, and I'd taken a taxi, and I told the taxi one by the 7-Eleven. This was the wrong one. It was a mistaken hotel issue, and I don't know why I've been here so long, but it doesn't matter at this point.
I don't know, I didn't read the facts, but usually something happened before they call the police on a potential customer, sir.
I asked for it.
So you're not sure which one you're trespassed from? It's one on Magnolia.
You know,
Okay.
we all just follow the GPS these days, don't we?
Okay,
Thank you. Sorry.
but you can't go back to that one.
Okay.
Are you doing this of your own free will?
Yes, I am.
You're not on probation for anything, because this would violate probation?
No.
Okay. And you're not, if you're not an American citizen, you could be deported, understood that?
Understood?
Okay. Well, it appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner, sir, and that the lawyers have stipulated to a factual basis, so we'll accept your plea of no contest, find adjudicate you guilty on the charge of trespass on property, and sentence you to the 23 days you've already served, release you as of this charge, tell you to not go back to the Courtyard Marriott on Magnolia. The cost of investigation to Orlando Police Department is $101.32. There's also court costs in the vicinity of something like $300. We'll give you a year to work on partial payments. You can pay those even through the clerk's website, sir.
And Your Honor, the Marriott, apparently his passport and items are at the Marriott. So I would just ask for a one-time return with law enforcement to grab his passports, IDs, or anything.
Actually, they're at the other Marriott, not the one on Magnolia. They're at the other Marriott, which I had intended to go to.
Well, hopefully they are.
Just a one-time return with law enforcement so he can grab that passport, Your Honor.
I have no identification is the problem.
Oh, that's a problem. One-time return is granted, and good luck in finding all that stuff. Maybe it could possibly be in the OPD evidence locker, so you might want to try there as well. Okay. You're welcome. Dylan Summers? Yes, ma'am. Okay, thank you, sir. This is an arraignment in regard to 21MM 2764. I think we ought to get the baby next.
May I ask you a question, Your Honor?
And it's a battery charge, so I don't know if they
Your
have
Honor-
had time within 31 days to get that one figured out.
No, Your Honor, we're going to enter a plea of not guilty.
All right, you might want to talk to your lawyer about it.
Division 50 pretrial conference, June 11th at 9 o'clock, courtroom 7C.
Well, at least your court hearing's coming up pretty soon for the pretrial. And a lot of times they've got something figured out by then.
Okay.
All right. Is there a baby in the witness room?
I believe it's a DV case, Your Honor.
Right.
Let me see.
I don't have it on the arraignments, that's why I was asking.
I'm confused.
Is this Mr. Estrada Rivera? Okay, thank you, sir. All right, this is case number 21MM3510 in,
Your Honor, I don't have this currently as an arraignment. I also currently don't have it filed.
Mr.,
Misdemeanor.
he's in the,
Okay.
he's in
Move up
the
list as
misdemeanor
arraignment.
batteries. I'm not sure. I guess he got moved up or something.
Okay.
And we can appoint the public defender if you want one, although we didn't get a public defender form yet.
Yes, Your Honor, I would ask that you appoint us on the case.
Okay, they had enough information to file the charge of domestic battery. I don't see a witness here.
Nope. Your Honor, I would just ask, I see that he was not interviewed for pretrial release. Is it possible that he's interviewed for pretrial release, and if he's qualified,
He's got some history.
Yes, Your Honor, I understand. If he doesn't, I would just ask that if he doesn't qualify for pretrial release, that you go ahead and set a monetary bond as an alternative.
Well, that would be normal. Okay, since the witness is not here, we're required to require no contact at this time until you can get into court and the judge can hear from both parties and can determine it's safe. Separate residences until that time. If you need a police escort to get some things out of a residence in order to abide by the no contact order, we'll approve a one-time police escort to get some things out of the residence. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of release. Other than that, in relation to the allegations, the size of the charge being a misdemeanor, but taking into consideration some criminal history, let's just set a bond of 1,000. Good luck to you. Oh, the Simpson case, I never got a police report on that. Simpson. Are you you're not Mr. Simpson, we just already did your case. Thank you. I'm not even sure where Simpson was. Simpson was a reset. All right, Mr. Simpson. Counsel, I saw that this was going to be a reset in case, I don't even have a case number on this, do I?
21 CF 5990.
That's right, I looked it up. I looked it up in Odyssey, and there still was not scanned any affidavit for an arrest warrant in regard to count 1, third-degree murder, felony murder, and count 2, attempted first-degree murder with a firearm. And were you able to secure one of those?
Yes, Your Honor. So I've done some trying to investigation this morning. It was reset due to the court trying to obtain an affidavit. I
Right.
did reach out to the ASA who covered weekend IAs, and she said that it was the covering judge's thoughts that the clerk would be able to provide one. When I check the clerk's site, I see that it's under seal. So I do not have the ability to get to
Well,
it.
you know, I looked in Odyssey, and it wasn't there, period.
there's no-
It's
When
just
I look at it,
somebody forgot to submit the paperwork.
Your Honor, when I get on the clerk's side, I see that it's under seal.
Well, okay, but
Um,
I have different access. I can see the things under seal, and I can tell you, it is not there, period. It's not there.
I have tried to reach out to our
Officer,
felony supervisor to see if they have any other additional information on this. And I currently don't have any other additional information. So I'll just ask that you at least pass them until second session, so I can try to obtain it or see if
Well,
it gets
I-
uploaded or
I'd
what
pass-
happens.
I mean, given the nature of the charges, I would pass it for, second session or tomorrow, either way, because
Yes, Your Honor.
somebody's going to have to track down a police officer who, I don't know where, well, I don't even know it's a police officer's fault, because the clerk's office is buried in paperwork, so maybe they misplaced it, but somebody did not scan this thing.
Well, I just asked that we move it to second session to see if I can obtain it, and then if we need to reset
All right.
the following day, I'll ask for it then.
All right, well, Mr. Simpson, I'm, sure you've been rousted a couple times over the case so far, but somebody did not either submit the paperwork or scan it in, and we're looking for it. It's too heavy of a charge for me to just say, never mind, let you out, okay? So we're still looking for the paperwork. You want me to keep it, or do you want to put it in another stack? I'll put it here, that way you don't forget it. Okay. Thanks. Is this? Okay, and, when was that? I think I remember this. Are we still on the resets?
Your Honor, I'll waive the appearance.
All right, those are, I get confused sometimes with everything. All right, so, okay, this is 21 CF 5987, and it is the second time she's refused court evidently. There was enough information for the charge of aggravated assault with a deadly weapon to be filed with threats to kill by a daughter while out on bond for possession of methamphetamines. In regard to the new charge, we'll appoint the public defender, tell her no contact with the alleged victim and separate residence, a one-time police escort to get things out of the residence if needed. Given all the allegations with the knife and the threats and the fact that she's out on bond counsel, I was inclined to set the bond at $5,000 on that. In regard to the possession of methamphetamine, the case she's out on bond for, 21 CF 420980, let's revoke and terminate the $1,000 bond and double it to $2,000.
Your Honor, state would ask for a condition of no weapons or firearms on the.
Oh, okay, if I didn't order that, we'll go ahead and add that. Thank you very much. Surrender within 24 hours, thank you. Okay, is this Angela Young?
Yes, ma'am.
Thank you, ma'am. Okay, this was case number 21MM1978A. It was a reset because you might have been in the hospital
Yes.
yesterday. Okay, I hope you're okay now.
Yes, ma'am.
So this was an alleged battery that was sort of read like a mutual, but evidently, sometimes when one person has more scratches or marks than the other one, the person with the least scratches and marks gets arrested, and that's might be what happened in this case. We can appoint the public defender to represent you, ma'am. We can't resolve it right now. And we would normally, because we don't have a witness here telling us it's safe, we would normally say no contact, separate residence. If you need a police escort to get some things out of a residence in order to abide by the no contact order, you can get a police escort for that. State also requests that if you have any guns, knives, or weapons, put those within the care of the arresting agency within 24 hours of your release. In this case, it notwithstanding some criminal history, I think that you might have met the PTR requirements? No, okay. All right, it was updated. All right, yeah, she's got some priors. And also there's a resisting charge, which was the arm tensing resisting. So let's set bond at 500 on the battery, 100 on the resisting. Appoint the public defender for you, ma'am. We'll give you their address and phone number so you can call them before your court date and get an appointment. And that's all we have at the moment.
Okay, can I, okay, and
You gotta speak with the board bondsman, I believe it's.
both of these? Or what size up? Thank you.
You're welcome.
Thank you.
Try to keep it down while you're out on bond.
Thank you.
You're welcome. Is this
Morning,
Miss?
Your Honor.
Is this Mr. Guzman?
Yes, ma'am.
All right, thank you, sir. We have it's called a felony case, 21 CF 6030, and we can appoint the public defender to represent you, sir. They had enough information to file the charge of, it's called aggravated battery whenever it's a battery on an alleged pregnant person. And we read that she said she didn't want prosecution, but if she's not here, we still are going to order no contact for now until both of you all can get into court and testify under oath that it's safe. And so that would be separate residence, police escort to get the things out of the premises in order to abide by the no contact order. But if you talk to the public defender, they should be able to get a hearing in regard to contact if need be, relatively quickly. But the victim does not have the legal authority to reverse this court order. You have to wait.
Understood.
And 7-year relationship, she probably knows about the criminal history. Let's just set it at 1,000. I know he's got some history, but,
Your Honor, state would also request no weapons, firearms, or ammunition.
okay, if you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. Make sure you go to all your court appointments, talk to your public defender before court. Good luck.
Yes, ma'am. Thank you.
You're welcome. Mr. Henry? Okay, sir. Forgot to tell you all, that last one's going to Division 19. Okay, Mr. Henry. The first one?
The last one.
The last one, I'm sorry, was 1,000. All right, Mr. Henry's case is 21 CF 6033. We do have a witness. All right, and unfortunately, a child seeing this, I guess you didn't have an opportunity to prevent the child from seeing this.
No.
Okay. Because she'll probably remember it.
I'm
forever.
sorry?
She'll probably remember it.
Oh, it's a boy.
Okay. I'm a little bit blind, but.
No, you're
I
fine.
do see that the shirt is blue.
You're fine.
All right. All right, so the, the allegation is battery with a strangulation, and also when it's a battery on a pregnant person, it becomes a felony. So we've got 2 alleged felonies. I understand you didn't want to prosecute at the time, but we need to get your testimony. And the state's not going to drop the charge, but we're talking about release conditions and what is safe, okay?
Yes, ma'am.
All right.
May I inquire, Your Honor?
Yeah, she previously got sworn in, I think, correct?
I'm sorry?
Did you get sworn in earlier?
No, Your Honor.
Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you.
Good morning, ma'am. Can you please state your name for the record?
Yes, Shayla Bowden.
Okay, and can you spell your last name?
Spell my last name?
Yes.
Yes, B as in boy, O-W, D as in dog, E-N.
Thank you. And what is your relationship to Mr. Henry?
My boyfriend.
Approximately how long have you known him?
5 years.
And has anything like this ever happened before?
No.
If anything ever like this happened in the future, would you feel comfortable calling 911?
Yes.
Are you afraid of him?
No.
Do you want to have contact with him?
Yes.
And do you believe drugs or alcohol played a part in this incident?
No.
Right, thank you. That's all I have, Your Honor.
All right. Anything to add from the prosecution?
No, Your Honor.
Right, sir, I'm not seeing a public defender application, but I think you probably, we normally will appoint the public defender temporarily. If you didn't fill it out because you want to get a private attorney, that's okay. Just have them substitute, but we want you represented from the beginning. Understood? All right, and if you think you want the representation, it would be helpful if you fill out one of those forms. All right, they have enough information, at least file the charge at this point, and so we'll find probable cause, tell you to not have any hostile contact, that means no fighting or, you know, that could be a violation of your release conditions, and it's, land you right back here. If you have any weapons, guns or knives, put those in the care of the arresting law enforcement agency within 24 hours of your release. And I think there's no violent history here, other than what the sort of allegations are that we're not real clear on what happened exactly. I don't want to minimize some of the allegations, but then she tried to retract it.
Could I say something, Your Honor?
You know, you might want to talk with the lawyers too, because saying stuff and then kind of saying that it's not true, that is a crime in and of itself. And I don't know what to say. I'm just trying to figure out what the bond should be, but he has no violent history, so I'll do something fair. You made some like rape allegations, and then later you said didn't happen or something. So you need to be careful about making reports. I don't know if it's true or not. If it's true, the bond amount would go way up.
No, ma'am.
Don't say anything. You have the right to remain silent. Making a false report is a crime, okay? So just don't say anything about that right now. Talk to the lawyers, not on the record.
Yes, Your Honor.
All right. And I know sometimes those are ambiguous situations, and you get confused and you don't know exactly what to say about it. No. But I tell you, it obviously would have an impact on the bond, and that's why I'm mentioning it, because it creates some, what I would call cognitive dissonance for me, and I don't have time to explain what that is. But I'm going to set the bond according to the things that the police officer put down. So battery by strangulation, count 1 is 1,000. Aggravated battery because of the pregnancy is a secondary charge at the moment at 150. Just talk to the lawyers and figure out what to do next. Make sure you appear at all your court dates. If you want to drop charges, you got to talk to the state, ma'am. You know, it takes a while. They have to talk to you about it.
Okay.
That's it. I just set bond.
Okay, what is the bond?
It's 1,000 on count 1, 150 on count 2.
Okay.
All right, is this Mr. Maldonado Hernandez?
Yes, ma'am.
Sir?
Yes, ma'am.
Thank you very much. We have case number 21 CF 6023AO. It's going to Division 10, Council. And I don't see a witness here on this particular case today. Let's appoint the public defender. Council, it looked more like aggravated assault than ag battery of the firearm. Did you want a minute?
Yes, Your Honor.
Okay, no
I
problem.
agree with your recitation. State would ask that you find PC for the ag assault. Instead of the ag battery, it is a lesser included.
Okay,
And I'll look up a statute right now.
okay. Yeah, as to count 1 ag assault with a firearm. Do you happen to know the statute off the top of your head?
I'm looking it up right now, Your Honor.
Sometimes the clerks know it because they've written it down a million times.
An aggravated assault with a deadly weapon would be 784.021 sub 1 sub A. It's an F3.
Okay, thank you. Well, I think it was still supposedly a firearm, but, yeah. We don't know if it was capable of projecting. It was a rusty pistol allegedly. So, sir, that is more of an assault than an aggravated battery with a firearm, so we just found probable cause for that charge instead of the higher one. And the first thing that we would say, since we don't have a witness here today, would be no contact with the alleged victim's separate residence until a judge can hear from both sides with sworn testimony and make a determination that it's safe. If you need a police escort to get things out of the residence in order to comply with a no-contact order, we'll allow you to have a police escort to get some things. In the meantime, public defender, if you need to try to get that no-contact order looked at by a judge, you need to go through your public defender and get a hearing set, all right? There was maybe a child that could have witnessed the situation, in which case we would say no contact except as allowed by order of the Department of Children and Family Services and/or juvenile court for now. Or as otherwise ordered by the trial judge in this case. So we want to be consistent with anything juvenile court does. If it got referred, but it probably did get referred to Children and Family Services if a child might have witnessed a crime, okay? I don't know if I told you to submit any guns, knives, or weapons to the care of the arresting agency within 24 hours of your release, but that's the normal order. Sir, I will admit to getting a little bit conservative on charges involving any kind of gun. So even though it was an aggravated assault instead of a battery with a firearm, I generally tend to put $5,000 on those bonds involving guns. The battery would be 100. And that's all we have for you today. You do have a bond, it's just higher because of a gun. Good luck to you.
Would you be inclined to reduce the $5,000 bond? He does qualify for pretrial release, so place him on pretrial release and reducing it a little so that he is able to post the bond. If he violates any condition with pretrial release, he'll be brought back here.
I guess this, I might have not even noticed a pretrial release because once I see a gun, my brain goes in a different direction, to be honest. And, you know, this was what I did for all the years when I did this kind of work in the past.
Your Honor, state would just point to that he does have previous DV history with this same victim. And in the affidavit, once he enters the apartment with the firearm, he does cover her mouth.
And I'm not asking that he not pay a monetary bond. All I'm asking is that would you be inclined to lower the $5,000 a little and place him on pretrial release so that he is able to post the bond amount, Your Honor?
Oh.
So,
in other words, add pretrial release as an additional condition to attempt to assure safety.
yes, Your Honor.
Okay, 2,000 plus pretrial release.
Thank you.
Evidently he qualifies. It's just not something I'm used to pretrial releasing people on a gun charge.
That's 2,000 and 1,000, or 2,000 and 100.
2,000 on the one and the 100 on the second.
And
TR
bond
on
and-
both charges. Thank you very much.
Thank you.
All right. Is this Mr. Benias? Thank you, sir. So 21 MM 3500. They had enough information to file a charge of domestic battery, sir. If we don't have a witness here, then we need to require no contact for now. Although I would say it's a one-sentence allegation, but I think it would hold everybody up for me to give the state more time to get more detail. I guess the police officer doesn't like to do paperwork. Might work out in your favor in the future. I don't know. He was very, oh, she's here. They were both arrested? I'm sorry. All right, so I'm going to back off on the no contact allegation. And was she also, all right, okay. I didn't catch that you were both arrested. Okay, so both of you qualify for pretrial release. And the state probably wants to ask you both if you're safe for contact with each other while the case is pending. Pretrial release means you can get out without posting any financial requirement to come back, and you can go back to South Carolina. But we have some questions about contact while you're out on pretrial release.
Your Honor, for the record, are you Ms. Pilata, 21 MM 3499?
And let's just say that both of you have the right to remain silent, and everything's getting recorded, could be played back at a trial. So you might want to be careful about talking about the facts. We're really concerned about safety while the case is going on.
Mr. Benias, can you please state your relationship to Ms. Pilata?
Her mother's kid, her mother's father, her kid's father.
Okay. And approximately how long have you known her?
3 years.
Okay. And has anything like this ever happened before?
Never.
Are you afraid of her?
No.
And do you want to have contact with her?
If I can see my child.
And Ms. Pilata, can you please state your relationship to Mr. Benias?
He's an ex-partner.
Okay. And has anything like this ever happened before?
No.
Are you afraid of him?
Yes.
And do you want to have contact with him?
No, no, ma'am.
Thank you. That's all I have, Your Honor.
Okay. So I noticed that you were all right, so Ms. Pilata lives here.
Correct.
And Mr. Benias lives in South Carolina. So you don't live together, and the no contact issue's pretty easy to maintain then? All right. And in regard to, can visitation be accomplished through a third party, such as a trusted family member?
We're in the middle of a court. We're going through court to establish visitation and paternity and all of that right now. There is no set up visitation. I've been allowing him to come to my home to visit her since he doesn't live in the state. But we'll have to talk to the attorneys and set something else up.
Your Honor, given that they're currently in, it seems like dependency court, I'd ask that you make no findings as to visitation of the child.
I don't think it's dependency court. Is it, what kind of court is it?
Family, I think family court. I'm not sure. We had a mediation on Tuesday.
Well, was it an injunction? I mean, if you're not married, you're not getting a divorce.
No, it's just to set up visitation and child support and all that.
All right. All right. Sir, my first response would be just to follow the requirements that are going to be set in circuit court in regard to child visitation. Are you okay with that?
Yes, ma'am.
All right. Okay, let's just do that. No contact. With each other or and child visitation is pursuant to circuit court orders, And the no contact order in regard to each other is going to be also pursuant to the circuit court order. So it's no contact except as pursuant to circuit court orders. If that makes sense.
Your Honor, in lieu of separate residences, state would just ask for no return to the victim's residence.
Okay, no return to Ms. Pallotta's residence unless authorized by the circuit court orders. 'Cause I don't know what they're going to come up with down the line. And both of you qualify for pretrial release. Sir, you're not prevented from going back to South Carolina as long as I order that you can go back. For both of you, if you have any guns, knives, or weapons, put those in the care custody of the arresting agency within 24 hours of release. Now, normally, we would want to appoint the public defender for you both, but what happens is the public defender actually will withdraw from one case because there might be inconsistent defenses, and so they will request that the court appoint a separate lawyer in one of your cases. And whichever you gets another lawyer, just be careful, because there might be a couple weeks when you don't know who your lawyer is. I'm sorry to tell you, but sometimes the paperwork takes a little while for them to appoint you a lawyer. But I just want to advise you that you might need to make sure you can keep up with the court paperwork. You can always look on the clerk's website. You know, a lot of this stuff is public information, so if you get confused about who's got the court-appointed lawyer and what their address and phone number is, it might end up in your paperwork online. Usually you want to follow up with who your lawyer is. All right? That's it for now. Good luck. Oh, he can return to South Carolina. Yeah, thank you. Is this Shalia Johnson? Okay, thank you. This is case number 21MM3502. And we can appoint a public defender to represent you. They had enough information to file a domestic battery charge. Looks like you qualify for the pretrial release program. You can go back to New Jersey if that's where you live, but you don't have to stay in contact with the pretrial release program and attend your court dates when required. Keep in touch with the public defender in order to possibly save you one or two of those court dates on your behalf. They can represent you, but tell you when you have to really come back. Since the other person is not here today, we'll order no contact, at least until a judge can hear sworn testimony and determine that it's safe from that alleged victim. If you need a police escort to get some things out of your mom's residence, we'll allow police escort for that.
So are you ordering separate residences, Your Honor?
Separate residence. Were they both here on vacation?
Yes.
Oh, okay. And then follow any requirements if Department of Children and Family Service, I think they were allegedly, she was asleep in the car, but if the Department of Children and Family Services got notified, they might have some orders in regard to the child having allegedly observed a criminal charge, and you would follow any requirements. In this case, will be consistent with any orders by Department of Children and Family Services in relation to the child. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. And we wish you good luck, ma'am.
Thank you.
You're welcome. Is this Ms. Moore?
Ma'am.
Thank you. We have case number 21MM3505. And the witness finally gets an opportunity to come here, although he's been waiting for a little while. Thank you, sir. Were you sworn in at the beginning?
Yes, ma'am.
Okay, thank you, sir. Now, it looks like they have enough information to file the charge, and, we're going to ask you whether or not you want contact and if it's safe and all that, right?
Yes, ma'am, that's fine.
Okay, State will ask you some questions.
Yes.
Good morning, sir. Can you please state your name for the record?
Gregory Palacios.
I'm sorry, can you speak up a little bit?
Gregory Palacios.
Thank you. And can you spell your last name?
It's spelled P as in Peter, A-L-A, C as in Charlie, I-O-S.
Thank you. And what is your relationship to Miss Moore?
We've been in a relationship for three years.
Three what?
3 years.
Okay.
Are you afraid of her?
Not at all.
Has anything like this ever happened before?
Just once.
Okay, approximately how long ago would you say that was?
2 years ago.
And do you want to have contact with her?
Yes. More so. She actually helps to care for my mom and dad. So.
Okay. And do you believe drugs or alcohol played a part in this incident?
No.
Okay, thank you. That's all I have, Your Honor.
Thank you as well.
Okay.
And Judge, thank you for your over 40 years, right?
For what, sir?
Thank you for over your 40 years of service, which is what I heard you say when we had started.
Oh, no, it's 22, but thank you. You're quite welcome.
Thank you.
Okay, now, she's on felony probation in Virginia, but they're probably not going to extradite. The reason I mention it is we try to figure out what appropriate release conditions will assure that she comes back to court. Do you live here?
We both do. We live in my parents' first home, which she helps care for.
All right.
I'll be sure that she makes it to court. That's not a problem.
All right, so, all right.
Your Honor, she does have
She has-
5 prior failures to appear.
Yeah, she's got failures to appear in Virginia also.
Yes.
All right.
Ma'am, if it pleases the court, my mom and dad are still on their way back from Miami, and they need her. I still work.
All right, so you guys were at the airport for your parents then?
Yes, ma'am.
All right, I get it. Okay. That answers my questions. Okay. Anything else, State, besides the no weapons and no hostile contact?
No, Your Honor.
All right then, Ms. Moore. It seems like you guys can figure out how to manage this without any
Yes,
more
ma'am.
problems while the case is pending. So we'll find probable cause. I'll set bond at 500 instead of hiking it up because of the,
Ma'am, is it possible for a PTR? I had to arrange my parents' flight plans, and that cost me.
I don't think she's gonna
Doesn't
get it with
qualify, Your
that.
Honor.
She's got probation warrant out of state.
She doesn't qualify because she's on state probation.
Right. So $500 bond is probably about as good as I can do.
That's fine.
All right. No hostile contact, no fighting while the case is going on. If you have any guns, knives, or weapons, put those in the care of the arresting agency for safekeeping within 24 hours of your release until the case is over with, and good luck.
Thank you.
Mr. Morgan, is that you? Yes, ma'am. Okay, thank you. And we have a witness. Ma'am, were you sworn in before?
Yes.
Okay, thank you very much. So it's case number 2021MM3512. It appears that they have enough information to file a battery charge, but he might qualify for pretrial release. Ma'am, the state wants to ask you a few questions about safety while the case is going on.
Good morning, ma'am. Can you please state your name for the record?
It's Hope Eller,
And what is your relationship to Mr. Morgan?
boyfriend,
Okay, approximately how long have you known him?
September of last year.
Okay. And has anything like this ever happened before?
No, not really.
No? Okay. And are you afraid of him?
No,
Do you want to have contact with him?
please.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
And do you believe drugs or alcohol played a part in this incident?
I'm sorry, what?
Do you believe drugs or alcohol were involved?
No.
No? Okay, thank you. That's all I have, Your Honor.
Okay. I'm assuming you all are gonna go back to Tennessee and you might have a plane flight or something. So I'll authorize that you return to Tennessee on pretrial release, but you'll need to keep in contact with the pretrial release office. But you don't have to post bond. Do you understand me? All right. Now, you didn't fill out a public defender form. Oftentimes, the lawyers want the public defender's office to be appointed temporarily just so they can get the paperwork started. But if you're planning on getting a private attorney, they can substitute in for the public defender by filing their paperwork. Normally, you would want a local attorney instead of getting somebody in the other state because you don't want to pay for them to fly down here. So check that out if you intend to get a private attorney as soon as possible. So no hostile contact means no fighting or more law office involvement circumstances while you're out. And always we say that if you have any guns, knives, or weapons with you here in Orlando, put those in the custody of the arresting office within 24 hours of your release for safekeeping while the case is pending. Right? That's all we have. You can get out, but just make sure you come back to your court dates. The case won't go away immediately. It usually takes about 3 hearings. Okay. Is this Ms. Smith? Yes, ma'am. Thank you, ma'am. The case number is 21MM312AW. And Ms. Smith, the paperwork, do you get that amount of income every 2 weeks?
Well, I just started getting this the other 2 weeks because I just got a raise from my job. So yes, I am going to be getting it every 2 weeks from here on out.
But before you did not?
No,
How much did you make before?
it was close to it, like in the 900s, like at least 955.
So you're in a situation where really technically, you have to be really have a very low income to qualify for the public defender. So technically you don't apply, but we'll appoint them temporarily, number one. Number two, my guess is you're not going to be able to afford a private attorney anyway because you're so close to the line as far as qualifying. So when you do come back to court, if you have tried to get a private attorney, let the judge know what your efforts were, and they might be able to stretch and qualify you for the public defender anyway. Did you hear me okay? All right, so you're really a little over the line there, but you might qualify if you try to get a lawyer and you can't.
Alrighty.
All right. It looks like you qualify for pretrial release. You would need to just maintain contact with the pretrial release office and follow their rules. Make sure you come back to court for your court dates. Check in with your lawyer so they can get the case started and be prepared. Since your sister's not here, we're going to have to say no contact for now until a judge hears from both parties and determines that it's safe.
Your Honor, state would also ask for no contact with the witness. I believe the pepper spray also got on her.
And I don't remember who the witness was. Was it another family member?
Yes, Your Honor, Nyla Jackson.
Oh, okay. The grandmother?
No, Your Honor, I believe Miss Audrey Daniels was the grandmother. She was the intended.
Okay. All right. No contact with Miss Jackson either. And I don't recall if if anybody was living at that residence and if,
Your Honor, state would still request separate residences with a one-time return with law enforcement.
separate residence is typical if we haven't heard from any of the alleged victims. If you need a police escort to get some things out of the residence in order to comply with the no contact order, we'll allow a police escort. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release for safekeeping while the case is going on. So that's it. Make sure you attend your court dates. Good luck to you, ma'am. Is this Mr. Weisbrook? Is that you?
Correct, yes,
Thank you, sir. Thank you. All right. The case number is 21MM3506. And the paperwork indicates that you might not qualify. Is that your weekly amount of income, sir?
Yes, it is.
Okay, so you're not wealthy, but technically, sir?
I'm supporting a family back in Alabama as well.
Oh, you didn't put that. You put one dependent. How many dependents do you actually have?
I have a total of 5.
All right, well, then you would end up qualifying under that scenario. Okay, so we'll appoint the public defender. So the witness isn't here, so we're going to need to require no contact for now, separate residence for now, at least until a judge can hear from both parties and determine that it's safe. If you need a police escort to get some things out of the residence in order to abide by the no contact order, we'll provide the police escort so you can get your clothing and belongings, at least until you get back to court and there's testimony that it's safe.
How do we go about doing that?
Call your public defender and ask him for a hearing on the no contact order, but not the alleged victim who doesn't have authority to change this no contact order. It has to be a judge and it has to be through the court hearing. And did we have information on the state probation? Didn't see paperwork on that. Is it out of state or something?
I believe it's in-state, Your Honor. I believe it's from Pinellas County.
Pinellas?
Yes, Your Honor.
All right, well, I don't have paperwork that requires me to do anything, so I'm assuming that you might have a hold. And the paperwork seems to indicate that there's a hold. And my guess is that they're holding you not.
There's no hold.
Your Honor, you can find an on-view violation and hold them no bond pending that paperwork coming through.
And how long does that last?
What, the on view?
Yeah.
Just until we get correspondence from his probation officer to see if they want to do, to violate him or not.
Well, they're probably not going to say they're not going to violate him, but how long do you wait?
I'm not sure, because he's not a violent felony offender, so we can't hold him for like the 5 days. So it would just be a no bond until, the
Until
judge or a
whenever?
probation officer releases him off of it. If his probation officer doesn't want to violate him, then the charge will be released.
Then you would reverse the order in regard to no bond?
Your Honor, I would just ask that you take no action if the probation officer wants to violate him then he can do that. But for now, Your Honor, I would just ask that you not do an on-view violation.
Does anybody know what the probation is for? I just have a notation, it's state probation, not what it is.
I believe it's a DUI, Your Honor.
A DUI, all right. Okay. All right. Well, sir, drinking appears to be the problem. And we do these on VOPs when the police officer writes it in his report, so we have the same level of probable cause. But I worried, I guess, on this one, in relation to how long that lasts with no paperwork, no paper trail. But if you're on probation, here's the thing. If you bond it out, you probably just get rearrested anyway. So maybe it is better to go ahead and,
If I were allowed to go on ROR, I would report to my probation officer today.
Your Honor, he doesn't qualify, given the nature of the
I don't,
charge.
that is wishful thinking. That you would get out ROR when you get a new law violation on state probation.
I guess I had not considered that.
Well, it's a clue as to how well you're going to be able to react and make better decisions in the future, because you don't have any idea how deep you're getting. And at some point, if you ever do, maybe that will make an impact, but that hasn't happened yet. And it needs to happen unless you like coming back here. It doesn't give me any pleasure, sir. I'm trying to figure this out because, as they said, that you're evidently abusive when you drink. Let's go ahead and do the inevitable, sir. They're going to probably file a violation. They're probably going to come get you. Let's go ahead and find an on-view violation on that state probation case. Hopefully they got the paperwork, at least the case number, and they'll check with the probation officer. On the new charge, based upon me revoking, we'll set a $500 bond, no contact with alleged victim, separate residence, police escort if you need to get things out of the premises, if you get out otherwise, and put any weapons in the care custody of the law enforcement agency within 24 hours. That's if you get out on the probation. We don't have a case number. That's the problem, isn't it? Does anybody have a case number?
And what county was it?
Pinellas.
I need a case number for the court order.
I can look on.
I'm looking at it right now. Hold on.
If you can't find any other treatment, Alcoholics Anonymous is free. And I've seen it help a lot of people.
I believe it was a DUI, leaving the scene of a crash and resisting without violence. I believe the case number is 19 CF 14446. 14446.
So 3 4s and that's it.
Yes, ma'am.
So I told another person today that one of my standard sentences used to be at the place where you're at, and I'm not sure what'll happen on felony probation because I was a county court judge, but I would normally look at a case like this and order 90 days of jail or 90 days straight. Alcoholics Anonymous. If you miss one day, you do the full 90 days of jail. You might want to start preloading your Alcoholics Anonymous. It might help you when you get to court, but that's assuming you get out on the VOP, and I don't know that's going to happen. So good luck.
So that violation of probation, that's I was not aware that that was felony probation.
Well, either way, you're getting in pretty deep. So good luck with that. It probably started out as a state because of leaving the scene with a crash. So if it didn't end up with a state, it might, I don't know.
Even the scene of the crash was never proven or it was dismissed.
You're in a high level of denial, sir, which means you're probably not
Sorry, I'm just
going
telling you what
to
they told me, ma'am.
pull yourself out of the ditch. Good luck. It's all right. I'm just sad. It breaks my heart, that's all. Yes, sir.
I typed the order. Can you verify this is what you want?
Okay.
I did out of county.
Yeah. I know, it makes me feel weird too. Yeah.
Okay. Thank you.
You're welcome. Thank you so much. All right. Is this Mr. Williams?
Yes, ma'am.
Thank you, sir. We're still on. Got it. Okay. All right, sir, we have 21 MM 3492. It's an alleged battery. I don't have a public defender form, but normally we want to have you get a lawyer to begin with so the paperwork can get started. Are you thinking about getting a private attorney? Okay, just have them file their notice of appearance and the public defender will withdraw. But the process of getting the paperwork from the state will have been started and you won't lose any time in regard to that. Okay. Now, it looks like a mutual, but when one party gets a little more cut up or bruised than the other one, then the one with the cuts and bruises gets to maybe not have to be arrested. So we're going to find that there's enough information, at least for the charge to be filed. And since she's not here, we order no contact for now until a judge hears from both sides and can determine it's safe. And follow any Department of Children and Family Services requirements in regard to any visitation with the kids, which I think are hers. And in regard to the living circumstances, it needs to be the separate residence for now, like I said, until the judge can hear about the contact issues. If you need a police escort to get some things out of the residence, until you have a court hearing, then you can get a police escort to get some things out of the residence. If you have any guns, knives, or weapons, put those in the care and custody of the arresting agency within 24 hours of your release. All right, this is another one where the first appearance information sheet got updated. Looks like there's some batteries, but it's mainly drugs. We can go with a $500 bond on this, based on it being a misdemeanor. Any questions?
No, ma'am.
All right, good luck. Okay. Mr. Black?
Yes, ma'am.
All right, sir.
Morning.
Good morning. Now, there's a complicating factor, maybe you might be on community control or probation, which means, I don't think I've seen any violation of probation or community control paperwork yet, but those things have a magical way of appearing if you're trying to bond out. But the case that we have right now is 21 CT 3750. Folks, it's going to Division 84. Public defender is appointed. The allegation is driving a license suspended with an obscured tag stop. Let's see, and they've given me the driving record here. Oh, looks like financial and a DUI
I
from
believe it was a
2018.
DUI suspension, Your Honor.
Yes, ma'am?
It was a DUI suspension. The sanctions were never completed.
Right. Yeah, all of his financials have been after that. Okay. All right, in relation to the driving while license suspended, sir, I'm okay with the $500 bond. I don't know what's going on with the community control or probation. Let's set bond on the misdemeanor. Like I said, the paperwork violating community control magically happens sometimes when you're trying to bond out. I can't help you with that. They'll probably bring it to me to sign later. And I may or may not remember the name because of the number of cases I've got.
Yes, ma'am.
Now might be a good time to try to reach back and deal with the stuff that you were supposed to do on the DUI. If you get a multiples, well, I think it might have got pled down to reckless, but if you get multiple driving while license suspended and looking at your driving history, you might have some unresolved cases that may or may not be DUI, but if you get 3 of those within 5 years, you get a 5-year revocation. So walking away from a DUI because it's really bloody expensive turns out to be impractical in the long run, because then you can never drive. If you can't drive, you can't work, and it's pretty bad. Good luck with that.
Yes, ma'am.
All right?
Yes, ma'am. Thank you.
You're welcome.
What's his bond amount?
500 on the driving license suspended. Okay. Is this Mr. Howard?
Yes.
Okay. All right, sir. Let's see, okay, you've got 21 CT 873 AW. It's a no valid license charge. I guess rolling through the right-hand turn on a stoplight. And look at your, well, out on bond. I don't know if you heard me talk to the other young man just a minute ago about, if you don't get control of the financial obligations, you end up losing your license for a long time eventually, and then you can't even hardly work and things like that. You've got a fair number of suspensions, so I don't know if you've just given up, but I recommend that you not give up. Well, I can see 5 dependents. I guess that's pretty hard to keep up with the financials.
Hold on. Your Honor, the state's offering adjudication of guilt credit time served for the no valid driver's license. I spoke with Mr. Howard. He would like to accept that offer here today and resolve that case.
Yeah, that's actually a pretty generous deal.
And because he's resolving that case, I just ask that you take no action on the out on bond charges, Your Honor.
One of which is a driving while license suspended. So if you, I know that, once you come back to court, they might, they'll see that you got this one and it it doesn't help your sentence on that case, especially considering the number of suspensions that you have.
He's actually supposed to make, they're working with him to get his driver's license. He's actually supposed to make a payment, I believe he said today at 1 o'clock. He has a hearing.
What date?
Is it a hearing? Is it a hearing? Yeah, today at 1, Your Honor.
All right, then, Mr. Howard, if you want to resolve it, go ahead and raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. All right, I already told you that these things add up, but at least it's not called a driving while license suspended. The other one is, if you get 3 of those within 5 years, you lose your license for 5 years, and it becomes a felony every time you drive after that. So this is a very generous deal. It's about as good as you could get. Even though everybody will see that you got another one while you're out on bond for driving while license suspended. Do you understand all the rights on your plea form?
Yes, ma'am.
You won't have a trial, you won't have a defense, nobody will have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved it. Do you understand that?
Yes, ma'am.
If you had been on probation for anything, this would violate your probation. Do you understand that?
Yes, ma'am.
If you're not an American citizen, it could result in deportation. Understand that?
Yes, ma'am.
Any questions? All right. I'll find that you're alert, intelligent, entering a plea, no contest in a free and voluntary manner on the new charge, and no valid license. Find a factual basis, find adjudicate you guilty of that. Give you credit for, I think, 2 days, 1 day time served. Okay, and are we recommending no action on the other ones just because he got this one taken care of?
Yes, Your Honor.
All right, no action on the out on bond, sir. We all hope that you get your license back because it's just a mess when you can't work because you can't drive, especially with 5 dependents.
Thank you.
All right, thank you. Do we have a Miss Pittman? Oh, good. Oh, I'm so sorry. I forgot to tell him to pay his court costs within a year, but I think he could see that on the court paperwork. Okay. Sir, I forgot to tell you to pay your court costs within a year. I'll give a year to work on that so you can try to catch up on the other ones first. But this would be the anniversary of today's date that you'll be due on the court cost for this charge. If I give you a year to pay the court costs, we put court costs on every case. So you have a year for the fine on this case. You work on the other ones first. All right, good luck. You're welcome. Thank you. Oh, well, if, the PD usually doesn't want to be appointed because she doesn't want to have to charge him another $50. So she was just acting as a friend of the court for him.
Thank you.
You're welcome. Thank you for clarifying. Okay, so these are arraignments that we have left? Okay. We have a Travis Bridges. Holy cow. So he's been in on a petty theft and criminal mischief for 24 days and a VOP for 27 now?
Yes, Your Honor, we'll waive the appearance and enter a denial. Is it a POP?
Yeah, this paperwork might be as to the new charge, 21MM1333, as far as I can tell, on a petty theft and criminal mischief. Oh, wait,
No,
I'm
I believe
sorry,
that's
it
a
is a
VOP.
VOP.
It's a VOP, Your Honor.
All right, so we'll go ahead and set it, Division 2884.
VOP status, June 25th at 8:30, courtroom 4B.
Okay, it looks like we're at 33-day motions.
All right, I'm ready whenever you are.
Okay.
Want me to go through?
Yeah, thank you so much. The first one.
Robert Arce.
Arce, that's a familiar name.
21 CF 4499, notice and on filing.
Motion for ROR is granted. He used to have a mental health issue, didn't he? I remember him. Or at least-
Randy Alsdorf, 21 CF 4505, a no information.
Okay, is this Miss Christ or Christ? Huh? Is this Nicole? Oh, you got, all right.
Mr. Simpson.
All right, so this is Mr. Simpson. All right, Mr. Simpson, this case involves case number 2021 CF 5990, and we did finally get the affidavit, the sworn statement by the police in regard to the warrant, about 19 pages or so, and I felt like I had to read it, even though another judge already found probable cause in relation to a shooting and death that occurred allegedly on May 2nd. So by the time they got down to trying to talk to people, looking at videos and looking at fingerprints on guns, the gun and ammunition, there's probable cause. Proof is evident and the presumption's great at this point.
Your Honor, state was just asked that you hold him no bond pending an Arthur hearing, given that it is a PPL offense.
All right, now, I'm not seeing a public defender application, but normally we're going to appoint one just temporarily. If you get a private attorney, then you can substitute them in. The PD's already filed a notice of invocation of constitutional rights. You don't have to talk to anybody. Did we have some out-of-county warrants on this also?
I don't believe so, Your Honor.
In Osceola? Okay, so, all right.
So.
Okay. So it's count 1, third-degree murder, felony murder, and count 2, for some reason they put attempted first-degree murder with a firearm. And it's no bond for now. Talk to your lawyers. Good luck.
Your Honor, as a condition, while he's sitting in custody, I'd ask for no contact with victims or witnesses or the victims' families.
That's fairly standard, sir. You don't want to be talking to people about their testimony or anything. Good luck. Okay, is this Nicole Renee Christ? No? Oh, okay. All right, so it's case number 2021, CF 6042 AO. Council's going to Division 11. Will appoint the public defender on her behalf.
I'll waive the appearance, Your Honor.
Waive appearance, thank you. They had probable cause for both the petty theft and the escape. And normally I'd put the escape at something like $5,000, but I'm more concerned about her being checked for mental health or Baker Act if she bonds out because of multiple threats to kill herself. Is that something we could put on there, that she'd be checked for mental health before she bonds out?
I believe they just do a standard check in the jail, Your Honor. I don't know if they'll do another check before she bonds. I'm not really sure of the procedures.
Well, she must have threatened that she wanted to kill herself about 4 times. And so, is there any order in pertaining to that? Because if you just bond her out, she might, do that. She seemed fairly intent. Can we put down that she should be checked for Baker Act?
Baker. I mean, would you, I don't know how that works if you're talking about Baker Act.
Okay.
Your Honor, I don't, if she doesn't otherwise meet the criteria, I don't know if the jail staff could.
All you have to do is threaten that you want to kill yourself, and you basically meet the criteria for Baker Act. Or finds that she might meet the material for Baker Act and request that the jail check her for Baker Act before releasing her.
Okay.
And whatever you all do with that is on you, not on me. She threatened to kill herself about 5 times. Just saying. Okay? I think she's really intent on that, and we should check. Okay.
Your Honor, are you ordering a no return?
To the Walmart or whatever it was?
Yes, Your Honor. And
Okay.
are you gonna set the bond amounts?
Oh, it's 5,000 on the escape. That's what I used to do, unless you guys have
Okay.
made it
And
lighter.
Staying the 500 on the petty theft?
No, it's a subsidiary at 100, but thank you for clarifying.
You said 5,000? 5,000? Okay.
On the escape, yeah. All right. So who is here? Marine? But we put all those up front. Okay. All right, that's case number 2021 CF 6016AO, Division 17. Will appoint the public defender on the behalf of Mr. Marine. It appears there's enough information to at least file the charge of destruction of evidence, count 1 at $1,000 bond, and resisting without violence would be 100 on count 2 as a subsidiary charge.
On that very first case that you just did, I just want to verify the verdict. You're not ordering her with anything of mental health charges. You're just ordering defendant to be screened for Baker Act criteria prior to release. And that's it.
Perfect.
Okay.
To be screened for
you.
Baker Act criteria. Thank you.
Okay.
All right, now, so Martin. Well, I have a Martinez Jansen. Is that who you're talking about?
No, Your Honor, there's 2 Martinez's.
Okay. I don't even know, well, I have the other, okay, so we need to pull that one out because I have a different one. Is that one also a felony?
Yes, Your Honor. 21 CF 6040.
Thank you. Okay. You want to trade? Okay, thank you. All right. Robinson Martinez, and I think you just said the case number on that, has a mental health circumstance preventing his appearance, will appoint the public defender in regard to his behalf.
I'll waive the appearance, Your Honor.
Okay, does have a little bit of arrest history with weapons, et cetera. And it's going to Division 22, Counsel. Let's find probable cause for aggravated assault with a deadly weapon at 2,500. A subsidiary or additional charge of Bat Leo at 150, resisting without violence at 100, and witness tampering at 150. No contact with witnesses or victim. Any release would involve giving any guns, knives, or weapons to law enforcement within 24 hours of release. That's it for now. Okay. Is this Mr. Henry?
Yes, ma'am.
Okay, thank you. All right, so I guess this is in the felony violation of probation group cases. In case number 2021 CF 6022 is going to Division 20.
I already had an attorney on the case, and I think he resolved everything.
Did you have a private attorney or a public defender lawyer?
I had Ken Yulo.
I've got more than one case here, so I don't know if you've got everything resolved.
No, Your Honor, I believe he has a private attorney on his violation case.
And is there any, I'm not seeing paperwork on the VOP at the moment, I don't think. So I don't know if that there's been a hold on that. Let me know if there is.
Your Honor, I have the VOP. It came in as a warrant.
You do?
Yes, Your Honor.
Okay.
He has a VOP for fleeing and eluding, as well as another warrant case.
Oh, okay. That's the 21 CF 3379, correct?
19 CF 13998.
All right, okay, all right. So probably there's a hold for that, sir, and you'll see the violation probation judge fairly soon.
Are you sure there's a hold on that?
Well, the state says they've got the paperwork. If anything has happened since then, I don't have that paperwork in front of me.
Pretrial, do you have the VOP? From case number 19 CF 13998? You have it too?
Yes, a
Okay.
warrant?
Yes, a warrant for VOP? Okay, I just wanted to make sure that he'd be held no bond on that. Okay.
You need me to print it?
You have it?
Yeah, it's in the packet.
All right, thank you.
Should be there soon. That
Well,
should be it right
oh,
there.
under here.
Yes.
I'm sorry.
That's okay.
Okay, you got a few, sir. Evidently, there is a violation of probation warrant on case number 2019 CF 13998. It's alleged that you violated probation by being charged, wait a minute, with driving a license suspended on March 19th. Perhaps some other charges as well, cost of probation, community service, and the driving while, and failing to complete a driving while license suspended revoked class. And you talk to your lawyer about that. In regard to some other charges, you have a case number 2021 CF 6022. That one is going to Division 20. And we can appoint the public defender on these until you get into court or your other lawyer substitutes, sir. Looks like you might qualify for the public defender. All right, sir. It appears that they have probable cause for aggravated assault with a firearm, shooting into a structure or vehicle, possession of firearm by convicted felon, use of firearm in commission of a felony. And I'm trying to find your face sheet here, too. It's going to be a little while before you get out anyway because of the violation of probation, sir, and this one was alleged to have occurred on May 22nd. Let's require no contact with any victims or witnesses. If you were to get out, any guns, knives, or weapons would be put in the custody of the arresting officer within 24 hours of release. In regard to aggravated assault with a firearm, guess it doesn't matter because of the VOP, but let's put $5,000 on count one, 150 on count two, 150 on count three, 150 on count four. There's another case, 2002-1 CF 3379, which was in relation to a warrant about some things allegedly from March 19th. I think those are the ones that are violating your probation. And the bond on that, probable cause having previously been found, 2,000 on count one, grand theft, 500 on count two, driving while license suspended, while revoked or third.
Well, my private attorney said that he had spoke to y'all. I've been here since like
Well, if the
2
lawyer
days.
has it under control, then he'll let you know. And whatever the trial judge does will supersede what we do here. And fleeing and attempting to elude, just put that at 150 because he's got enough things holding him, and the trial judges and the VOP judge will figure it all out.
Your Honor, just to be clear, you did hold him no bond on the VOP?
Yes, ma'am.
Thank you.
That's one reason I don't worry as much about the particulars. Okay, thank you. And is this Romello Alexander? You want to pass on that? That's out of county. Okay.
Yeah.
Is this an interpreter case here? Okay.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you very much. We have a few cases today. The first one is Mr. Oscar Gutierrez. And this, we can appoint the public defender to represent Mr. Gutierrez.
Se designa el abogado de oficio para que les represente. I'm sorry, Your Honor.
We can appoint the public defender to represent Mr. Gutierrez on case number 21CF6060. It's in Division 15. And we also need to make a determination that there's to be no contact with any alleged witnesses or victims.
Your Honor, he does qualify for pretrial release. Even though he has no criminal history, I would just ask this month pretrial release.
If you had a written indication that he qualifies, then there might have been an update because the work I have now says he does not qualify for it. It might be because of the charge itself.
There is an update, Your Honor.
Oh, that's one of the updated, I'm sorry. The updated says he does.
The case number or the charges on record?
Well, I put the case number so far. Alleged exposure charges, and when I read it the first time, the officer was indicating that it might have been a second or subsequent offense? Did you see the part about the second or subsequent?
Well, the first one was Wednesday, May 19th.
Okay,
He meant subsequent, like,
all right, not
on this
a
particular
prior
charging affidavit.
conviction. All right. What's your response to this defense's request for pretrial release?
He otherwise qualifies, and this is a non-violent offense. The state has no objection. My only concern is his proximity to the alleged in this case. I have no objection to continue.
Does he live near the other residence?
I believe it was like allegedly like 20-something feet or something like that.
Well,
yeah, I believe that their apartments like face each other. His back window faces her, I guess, front or back window.
All right. Any recommendations in regard to that?
Not that I can think of, Your Honor. He otherwise qualifies him as a non-violent offense. Other than
Not
explaining
making a
in
move
detail
out?
No, other than explaining in detail the no contact victim.
All right, keep your blinds closed, sir.
See?
Yes.
Because of your lack of prior criminal history, we're going to release you, but your neighbor is probably pretty worried, so don't have any contact, don't let her see you. And I would say that you need to keep your blinds closed facing her. We'll appoint the public defender. And if you have any guns, knives, or weapons, put those into your custody of arresting agency within 24 hours of your release. Make sure you make all your court appointments. Release on pretrial release is granted. Yes, thank you. All right, Mr. Soto Rosario. This is an alleged violation of probation on case number 2019 CF 16809. We'll appoint a public defender at this time. The allegation is that on May 23rd, let's see, the officers were encountering you in regard to case number 2002-1 CF 6036, and they conducted a narcotics investigation. They've established enough information to file the charge of possession of fentanyl, bond amount 1,000, possession of cocaine, 150 because it's a related charge, and resisting an officer without violence of 100. Another problem is that this violates your probation in regard to case number 2019 CF 16809. Those generally come in no bond, pending you seeing the probation judge fairly quickly. And was he also out on bond for possession of fentanyl case, or?
Yes, Your Honor. State would ask for no drugs or alcohol without a valid prescription.
No drugs or alcohol without a valid prescription, and evidently he was released on his own recognizance in regard to the prior possession of fentanyl. And possession of cocaine. So let's go ahead and revoke the ROR and place bond at 1,000 on possession of fentanyl and 150 on possession of cocaine, and appoint the public defender on everything for him.
You said 1,000, Your Honor, and what was the second bond amount?
150 is possession of cocaine. This is secondary charge. Thank you. All right. All right, we have two more for our interpreter. Thank you very much. Mr. Onel Cruz Gordillo. Sir, this is an out-of-county warrant for Lake County in regard to a failure to appear on a driving while license suspended case, and the bond amount for that is $2,000. If you bond out, you will be getting a court date to go to Lake County. If you don't bond, they should come get you pretty soon, and then you'll see the judge at that time. But that's just to inform you what you've been picked up on, sir. Good luck. This is our last interpreter case, I believe. Is this Mr. Alberto Rodriguez?
Sí, mire, yo quería decirle,
Yes.
Okay. The case number is 2021 CF 6048. And we can appoint the public defender to represent him.
hello, sí, mire, dígale que empecé un trabajo a $20 la hora hace una semana.
You have the right to remain silent, sir. You might accidentally say something about your case which could be used against you.
I would advise my client not to speak about the facts of the case.
Okay.
Sí.
Right. Okay, they might have enough information here to file an attempted burglary of occupied dwelling and assault. But I really wasn't clear. He doesn't have much of any criminal history, is that correct?
You should have an updated copy.
Oh, is that the update? Okay, thank you. All right, there's the information. Okay. As I said, we'll appoint the public defender to represent you. Get older. Bond, sir, the bond generally on this attempted burglary of occupied dwelling is at $3,500. You put the assault charge at $100. Appoint the public defender. No contact with the alleged witness or victim. If you have any guns, knives, or weapons, put those in the care of the arresting police agency within 24 hours of your release.
Your Honor, state would also request a no return to the residence.
Don't return to the victim's residence. Keep all this straight. Yes.
Hello. Ella tiene toda mi ropa y mis tenis no me los quiere dar. Yo no he robado.
She has my clothes and she has my tennis shoes and she doesn't want to give them back to me. I did not steal them.
Ella,
Your Honor, we did give a one-time return to any belongings.
I believe this case, he believes his wife was not his resident. The victim said, I don't know anybody by that name, she's not here. I don't believe the victim and the witness have any interpersonal knowledge of each other. So I would ask that you don't set a one-time return to a random person.
Oh, so when we had just
My
told
wife-
him not to have any contact with victims or witnesses, he's assuming that his wife was in there and she might be a witness and that we told him not to have contact with her. Okay.
I'll just clarify, the state asked that you have no contact with Juan Gomez.
All right, so we're not telling him not to have contact with his wife at this time?
No, Your Honor, she was not present or given the affidavit. I just asked no contact with Mr. Gomez.
All right, sir, we think your wife wasn't there and that you were worried about her being there. She was not, so we're not telling you that you can't have contact with her, but just him. Let's put victim then, so that's more clear. Thanks.
What is that?
Right. I think that would be all of our interpreter cases at the moment. What about Alexander? That's a recall, but is he an interpreter case or not? All right, thank you, Madam Interpreter.
Thank you, Your Honor.
Okay. Okay. Mr. Alexander. We have a warrant out of Brevard County in regard to what it looks like a misdemeanor case for a battery. And it might be a bond amount of 100 on that. Is that all we have for him?
Has he already been seen on the other out-of-county warrants?
Is there more than one?
No, Your Honor, it's just the Broward County warrant.
Okay. Sometimes when there's multiple pages, I'm not sure if it's one or more.
And that's just set out 100, Your Honor?
He evidently, and he might be on state probation, so I guess you have to report all of your arrests to your probation officer. But Broward County wants you for a $100 bond in regard to a misdemeanor case. If you bond out, make sure you attend your court dates on that and tell your probation officer about the arrest.
No.
Okay, good luck. A reporting? No.
No?
In,
Okay.
in general, you need to tell your probation officer. I'm just telling him that in general.
Okay, thank you.
Okay, thanks for clarifying that. Okay, are we back on pleables or something?
Do we still have Mr. Casimiro? The Portuguese interpreter case?
That won't be till the end of the document.
Okay, thank you.
All right, is this this gentleman being referred to as John Doe?
Yes. Michael?
Okay. It's case number 2021-MM3509, Division 85. And we can appoint the public defender if you want, sir.
I'm sorry, I couldn't hear you.
If you need to have a public defender, we can appoint their office to represent you.
I do need one.
Thank you. So we have, your name is Michael Persaud, P-E-R-S-A-U-D. According to the first appearance staff, he might qualify for pretrial release because they verified his ID and he doesn't have much criminal history. Was anybody trying to resolve it, or is he prepared to?
Your Honor, I didn't have his name until just now in court. I just got his updated face sheet, so I didn't have a criminal history to make an offer off of.
All right, do you want to, Sir, are you uninterested in knowing what their offer is, or do you want to get out on pretrial release and come back to court and see what your options are at that time?
You said I could hear what my options are now?
Yeah, but the state would just need a moment to look it up because they just got your name and they need to check your criminal history. So if you want to know what the plea offer is, we could take another case or two first and give her time.
So if you are going to make an offer, he's okay with resolving the case today?
Do you want me to pass this case?
Your Honor, I'm not sure I want to make an offer. I believe there's potentially another case for a trespass and potentially assault upon reading the affidavit.
Oh.
Your Honor, they didn't file that. It's a misdemeanor pleadable. We would just plead to the bench to.
Your Honor, no one's entitled to an offer at first appearance.
Well, no, I mean, a judge is legally allowed, but I tend to agree with the state on this, that, you know, it looks like there might be more than one thing going on, and I don't think it's too much to ask that he come back to court. Now, I will say this, and sometimes it takes the prosecutors longer than your arraignment to get to the bottom line of how many charges there should be and how all of it should be resolved. But I think it's sufficient to say that this place may have trespassed you before and they don't want you back.
Don't.
So, okay, if it was your first time, then you won't have to worry about it. We're going to release you on pretrial release anyway, which means you don't have to post a bond. And we'll appoint the public defender, so you've got somebody representing you. But I'll give the state an opportunity to figure out if they want to add a charge or not, because the officer said something about these guys said that you'd been verbally trespassed, okay? So they're going to figure out what all the charges are and hopefully help resolve the whole situation so it doesn't happen again.
Your Honor, state would also ask for a no return to Andretti indoor karting and games.
Right, don't go back there and don't have any contact with the alleged witnesses on this. Just go to court and see what they offer, and they'll talk to you about this, probably about the same things that you'd be offered here today. Maybe, you know, if you don't have prior history, you'll even consider something called pretrial diversion if it's offered. But just, you know, talk to your lawyers first, that might be helpful. Clerk wants us to update your name on the record as a Michael Persaud, P-E-R-S-A-U-D, according to jail staff. And I think he's in agreement that that's what his name is.
Yes.
All right, good luck. Actually, I don't know about pretrial diversion because of one cannabis charge, but, all right, is this Mr. Harris? Okay, sir. All right, we have case number 21MM3514 in Division 84, and possibly also 2021 MM3511 in Division 83. I think we can appoint the public defender if you need them. Are we trying to resolve these?
No, Your Honor, due to the contributing to a delinquency charge, as well as it being a stolen vehicle.
Okay. Let's go ahead and appoint the public defender then. Okay, so the first one is alleged trespass and basically in a vehicle. If you're even located in a vehicle and you figure out that, or should know that was possibly or probably stolen, they charge you with that. If there's another juvenile in the vehicle, they might charge you with contributing to the delinquency of a minor. And the other case number,
Your Honor, that's all I have for Mr. Harris.
no, okay, wait a minute. I had another thing attached in regard to, it looks like now a different person. Okay, so, well, let's just leave the bond at 500 on contributing to the delinquency of a minor, and the trespass would be a subsidiary charge at 100. And appoint the public defender. Make sure you come back to court for your court hearings.
Your Honor, state would ask for no contact with victims, witnesses, or co-defendants. In this case, Cameron Bellamy and Gabriel Bellamy.
Okay. Thank you. And I'm sorry, I had the next person's paperwork accidentally.
No problem, Your Honor.
Yes. Okay, here's this also, thank you. Okay. All right, good luck, sir. Well, the next piece of paper I have is a Christina Madison. All right, thank you. Is this Mr. Johnny Tran? Then, thank you. All right. The case number is 2021-MM3498. And the allegation is trespass and petty theft.
Your Honor, state doesn't have an offer at this time.
Your Honor, given the fact that he has no criminal history, employed full-time, I would just ask that he's released on ROR. It looks like he served in the United States Navy for 4 years, lived here for over a year.
Okay, so he didn't qualify for pretrial release, perhaps they couldn't reach anybody to make verifications, I guess? Was that part of it?
Mainly due to we have like no information, no address, transient, telephone, and I guess they couldn't reach his sister.
Right.
So we have nothing to supervise him on right now.
Well, he was in Disney World, so he's not a typical transient.
Your Honor, that's what the charges stemmed from, is he snuck in.
Is Walt Disney World?
Yes, he snuck into Walt Disney World
Oh,
through
snuck.
cast member entrance only
Oh,
areas.
okay. All right. Okay. Verified. All right, and you didn't want to make any kind of plea offer?
No, Your Honor, due to the areas of Walt Disney World that he was in, it potentially is like a Burke structure, and Walt Disney World likes to be consulted. Their legal counsel.
Because he went into the cast members, you're thinking of it as a burglary instead of a trespass?
Potentially, Your Honor. I believe there are other charges that could be filed on.
All right, sir, I don't know.
The state has no objection to an ROR, Your Honor, with a no return to Walt Disney World.
Well, sir, do you understand what release on own recognizance is?
No, Your Honor.
it's a way to let you out without making you post bond, but, because of your lack of criminal history, but you would have to come back to court. And if you don't come back to court during your court dates, then you get rearrested and it's hard to get out. Do you have access to the internet?
Yes, ma'am.
Okay, so then you could always check up on your court dates by looking at the clerk's website under records and your name. I was a little bit worried about them saying you didn't have an address. Maybe that's because they didn't have the opportunity to clearly interview you at the time last night,
No, they interviewed him.
interviewed you, but if you don't have a stable residence, at least you have the internet and you can keep up with your court paperwork, which tends to get lost when you don't have a stable residence. So the state wants to, they're thinking about filing more charges. I don't know if that'll happen or not, so just come back to court and see what your options are at that time. We'll appoint the public defender, and you can call their office, make an appointment before your court date.
Your Honor, state would ask that it be a condition of his ROR that he not return to any Walt Disney World properties.
Don't return to any Walt Disney World properties. They probably have a trespass warning out for you anyway.
Yes, Your Honor. I was actually told to come back to get my car, but I need an escort to do that.
Get your what?
My vehicle. I have a
Your
vehicle.
vehicle? Can you get a police escort to get your vehicle? Okay.
One-time return, Your Honor?
Yeah, one-time return to get your vehicle off the property.
With law enforcement?
Yeah. All right, good luck. We're keeping these officers busy. Okay, is this Mr. Yonamin? Yes? Okay, thank you. This is case number 2021 MM 3496, Division 84. And I'm not seeing a public defender application, but let us know if you prefer to have a public defender, sir.
Your Honor, state did convey an offer of an adjudication credit time served.
Yes, you can.
Okay, Your Honor. The state did convey an offer, however, my client doesn't want to accept it today.
Okay.
I would ask that he was not able to be interviewed for pretrial release. Oh, he has an open case.
Yeah, I would assume not. Open Broward case?
Okay. Oh. All right. Sir, well, the bond is 500. See if you could get somebody to bond you out and make sure you come back to court. If you're interested in pursuing your defense, you might want to call the public defender's office and make an appointment to talk to them.
Judge needs to put on.
We got a law, but he said that he's leaving.
I guess we can I'll bring it back up. Okay, Your Honor, he'll take the offer. He can't, because he's not gonna qualify for pretrial release, and, we'll accept the state's offer of an adjudication of guilt credit time served.
All right, sir. If that's what you want to do, did you look at a plea form yet?
Okay, Your Honor.
All right, so I'm going to ask you some questions, so go ahead and raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. I know some people go to trial on these, and we actually have a fair number of trials on the resisting charges, testing the perception of the officer and the perception of the guy. And so the first question in your mind was, I was just riding my bike down the road, and the officer's perception was you weren't going close enough to the curb, and in his perception, you were obstructing traffic. And if it's a kind of a minor violation about which some people could disagree, sometimes that causes people to start questioning the cop and, walking away and blah, 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 blah. And so ultimately it gets down to the jury deciding, was this enough of a hassle that the officer shouldn't have had to put up with this? And, it's just, the state was able to prove that the guy just, resisted or obstructed. Obstructed it's a somewhat of a subjective determination, but it really comes down to all the facts and circumstances. And, sometimes the jury will say, no, the cop, that's the kind of stuff the cop should have put up with. And other times it's like, no. And so, you're giving up your right to play it out and see what a jury would do. They would have to all be convinced that the state proved beyond a reasonable doubt that, actually, believe it or not, this is something that actually the United States Supreme Court decided back in 1996, is that they can stop you for just about anything. I mean, we've got some really small infractions out there, and, however far you were from the curb, I don't know, it's going to be a he said on your trial about how far you were and whether you're really slowing the traffic down. So it kind of starts there and goes from there. So you'll be giving up your right to play that out and see what a jury would do with it.
I was wrongfully treated, ma'am. I was abused. I'm a veteran, and I was not supposed to have been handled that way.
Well, I understand you're right. And so what you're telling me is you're just pleading out because you can't make a $500 bond?
No, ma'am.
I noticed you have a little bit of criminal history, so we don't normally qualify you for PTR, notwithstanding the fact that you're a veteran. But you don't ever have anybody in your family who wants to bond you out?
No, ma'am. I'm a slow.
He's living in the, Your Honor, he's living in the section 8 housing. I would ask, I understand the criminal history in this case of, it looks really nonviolent. He is a military veteran. If the state would be willing to, at least in this particular case, given the fact, withhold adjudication only because of his housing situation with the military, adding this to his record could potentially kick him out of the housing. I don't see much of a, it's usually, it looks like driving offenses and cannabis charge.
He's going to get kicked out of housing if he gets a conviction?
Yes, government housing is what.
So none of these other ones, the driving law license suspended was 2014, that's not a conviction, or it's not?
That was before.
It looks like before he got into the housing.
Yes, Your Honor.
My main concern is the other open case that he has.
Well, if that solves your problem about housing, I have the authority to withhold adjudication, if that's what you want to do.
That's all we would ask, Your Honor.
Okay. It's like I said, you could spend a whole day with a jury on this. And you won't know until the very end what they'll do. It could go either way. It really could. Especially the longer it supposedly took for him to get you to, deal with it. So you're probably a little closer to getting convicted than not, in my just guesstimation, but I've seen hundreds of trials in my life. That would be my guess. So, even though the first infraction was a teeny-weeny one, sometimes they give you a break for that. All right, well, I guess we've had a pretty long discussion about it, sort of, and I think that you are actually wanting to resolve it then. Did you understand your rights since we've talked about it?
Yes, ma'am.
All right, now, you also know that if you were on probation for anything?
No.
Because it'll violate your probation if that's what's outstanding in Broward. And if you weren't an American citizen, this could result in deportation. Any questions about that? Thank you. Okay. All right. I'm going to find that you're alert, intelligent, entering a plea of no contest in your of your own free will, and respectfully understanding the state's recommendation was reasonable. I'm giving you a break because of the housing and probably your military background too. So let's go ahead and accept your plea, withhold adjudication on resisting, give you credit for time served.
2 days.
2 days, find a factual basis, and release you as of this charge. We always impose court costs. I think they're a little over 300, but we'll give you a year to work on partial payments, and you can pay even through the clerk's website, I think. All right, good luck.
Okay, thank you.
Is this Mr. Whitman?
This is.
Okay, thank you, sir. I think you got picked up on a failure to appear warrant on this. And it was case number 2021 MM 51AA. And evidently there was a court hearing, and it says failure to appear for arraignment, and the bond on that is $1,000. So I actually didn't look up the background case, but we can appoint the public defender. We'll give you all the paperwork. If you forgot it, or if it was maybe a notice to appear that you didn't show up for and they found probable cause and you don't know about it, just look it up on the clerk's website. It should be scanned and available for your review, but make sure you come back for your court date. If it's an AA case, it's probably a POPCA that you'll be coming back for arraignment.
The court didn't have a former motion to appear.
Well, some judge thought that it was appropriate that you appear because they issued a warrant.
Oh, I understand. But this is the first that anything's been said about it. I hadn't appeared in court.
I wouldn't talk about the fact.
Previously related to this case.
Oh, okay. Well, if it's gotten confusing, then assuming you've got access to the internet, you might want to look it up on the clerk's website under records and under your name and find out whatever history has happened. Are you going to have a trouble bonding out or something?
I might.
Well, normally, I'm going along with what the judge did. If counsel wants to look it up, with your slight suggestion that there might have been a miscommunication, that you didn't get the information, I'll look at that if we find something. But other than that, I would not be changing the judge's determination on that. Can I cut to the chase, counsel?
Your Honor, the underlying battery, the facts are kind of egregious, and he does have a prior battery out of Brevard. So state would ask that you stay the bond at what was previously found.
So let me mention this to his defense attorney. Look, he said something about a miscommunication, that there was some prior thing going on with a case, and that he didn't get, I think it was his way of sort of beating around the bush saying that he didn't get noticed. Now, if that is actually true, it might be apparent, and then I'll give you some time. I'm going to go ahead and stay the bond for now, but if she finds that literally they didn't give you notice, I might adjust it, but it'll be depending on the paperwork or not that she finds. More often than not, when people tell me they didn't get notice, it turns out that it went out, and, you know, I end up staying the bond anyway. So I'm just going to let her look to see if she can clarify.
The sheriff told me that he was waiting for the warrant to come through after he had arrested me. We waited for over a half an hour, and then he...
That doesn't mean that it didn't exist.
There was a summons issued, Your Honor, and sent to his address for the arraignment date.
Okay, so here's what happens. There's a summons because somebody's made a report. You didn't get arrested initially. You supposedly get a notification sent to your last available address. You don't show up because either you moved or somebody threw it out with a junk mail or for whatever reason. But the judge, when they make a finding like this, they also could make a finding of probable cause. You know, a lot of times if they think that you didn't get the notification, they'll just send it back to the state to perfect service. But if they think it's, you know, there's probable cause anyway, they have the authority to say, well, looks like a probable cause to me.
So I'll just look this up at the on the clerk of court's website?
Yes, sir. You want to look it up, you want to follow up with it, you want to talk to your lawyers and, you know, see it, but it's a real case. You're going to have to deal with
Can you
it.
tell me when it was sent?
No, sir, look, the number of cases I've dealt with today is about 4 times this stack, and I did not look every single thing up other than the paperwork that I got. I'm doing the best I can. It's a $1,000 bond, and I'm going to move on to the next case. Good luck to you.
Your Honor, it has been brought to my attention that Mr. Tran, the defendant that we are award, he has intent to go back to Texas. That was not previously said in court, but I just wanted to let you know his intention is to go back to Texas, which is apparently where he's from.
Oh, so you brought him back? Okay, so, Mr. Tran, we saw your case a little while ago. It was the one that supposedly you kind of snuck into the Walt Disney World cast entrance and took some items that were not paid for, and
The petty theft was the cost of entrance, Your Honor. It wasn't an actual item.
was the what?
The cost of entrance into the park and the parking.
All right. And evidently, staff or somebody says that you intend to go back to Texas before your court date?
I technically live in Texas. My job is there. I don't have a home.
Your Honor, my client stating that he is in fact, homeless, which is why the address could not be given to the court. To pretrial release. He is planning on returning back to Texas, after he gets his vehicle. So, we would just ask that, he's able to return to Texas. He stated he does have a way to communicate with the public defender's office. He has an email, he has a telephone number that he can provide. As long as he stays in communication with the public defender's office here, Your Honor, I think that there won't be an issue with him, in court.
Okay, if I'm remembering correctly, he didn't have criminal history, and so that's why I considered the ROR. The state was seeing something in the police report that made her think there might be some burglary charges, and I confess I probably was reading it faster than her, and so I didn't see what that was, other than a trespass, getting into Disney World. I will tell you this, I don't, think the world is going to fall off its axis if you don't come back here, and I don't know that Florida's going to extradite, but you would have a warrant out for your arrest that'll just sit there and clutter up your criminal history if you don't come back and deal with it. Which, you seem like an intelligent young man, so eventually you'd have to come back and deal with it anyway, because, it messes up things like getting a good job and things like that, if you have a warrant out in Florida. So, I let you out, and basically what you're asking for is the same thing we'd probably grant anyway. If you're eligible for pretrial release, you can't be eligible for pretrial release because you're homeless. That also means it's less likely that you're going to find a way back here. But I'm just telling you, there'll be a warrant out, so make your own decisions on that basis, because all we do if you don't show up is we just issue a warrant. And it protects the citizens and taxpayers such as Disney World anyway, because if you don't come back, you don't come back, and they don't have to worry about you sneaking in again.
Thank you, Your Honor.
All right. You might want to get stable if you want to get pretrial diversion on this. Okay, sure. Well, yeah. Authorizing return, I'm just telling them to show up or we'll issue a warrant.
The county ordinance?
Okay. We have Mr. Coleman, right?
It's in the statute.
Yeah.
Yes, ma'am.
All right, thank you. It's 21CO665, Division 62, soliciting without a permit. And it appears that they have enough information to at least file the charge. Yeah, and probably we could appoint the public defender if you needed one, sir.
Your Honor, the offer the state's willing to extend is an adjudication and credit time served.
And he's out on bond for dealing in stolen property, receiving money for broker. Then, would you be recommending that I take no action on that?
Yes, Your Honor, if you otherwise pleased to this.
Your Honor, he would like to accept the state's offer here today
All right.
of an adjudication of guilt, credit time served. And he's gonna go to work before the court talks. It's what he said to the court.
Well, I get 2 checks a month anyway, and I can work on my SSI, my SSDI.
I can't really hurry you. Something about SSDI, but,
I'm just saying, that's my money I get every month.
right.
Actually, I can go to work on that money as well. I can work for a temp service, so I do that. Just going.
All right. Well, sir, the bottom line is that you just can't get a license if you're not paying your fees and fines on your criminal cases, and you've got a few. I don't know if you've kept up with them in the past or not, but, Other than that, we just give you a year to work on partial payments.
Okay.
All right. If you want to resolve it, look at the plea form, make sure you understand it. After you know that you understand the plea form, go ahead and sign it, and then look up, and I'll get you sworn in. All right, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth? All right, you can put your hand down, Mr. Coleman. All right, sir, thank you. Thank you. Sir, you're familiar with the plea form? Do you understand what's on it? Okay. You won't have a trial, you won't have a defense, nobody will have to prove beyond a reasonable doubt that you were soliciting without a permit if you accept this plea offer and accept the conviction on your record for soliciting without a permit. Do you understand that? Are you doing this of your own free will?
Yes.
Okay. If you had been on probation, this would violate your probation. If you're not an American citizen, this can result in deportation. Understood? All right. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis to accept your plea. We'll accept your plea of no contest. Find adjudicate you guilty of soliciting without a permit. Sentence you to the, I think, 2 days? 2 days. Time served, thank you. Court costs are something over 300, and we'll give you a year to work on that before there's any suspension of your license. And the state, given that your resolve in the misdemeanor is not requesting any action, you probably know it's a violation of your release conditions on the felony case to get a new criminal charge when you're out. And be careful about that, because depending on the prosecutor or judge involved, you could be no bonded on the felony, even by getting a misdemeanor charge. Okay. Good luck. This one I need to sign. Oh, okay. Thank you. All right. Is this Mr. Mickens? Okay, thank you. This is, the new case is 21MO602, Division 85. Sir, if you need the public defender, let us know. I'm pretty sure you might qualify. The allegation is possession of open container.
In your honor, the state is offering a withhold of adjudication credit time served. I did have a chance to speak with Mr. McKins, and he would like to resolve the case today.
All right. Did you say, I can't remember whether you said withhold or adjudication.
Withhold, your honor.
All right. He's got priors, but I think it's because of the charge itself.
Yes, your honor.
Okay. All right, and there's a charge that's outstanding, a possession of meth, resisting, witness tampering. Are we taking no action on that?
Yes, Your Honor.
All right. Mr. Mickens, make sure that you understand the rights on the plea form before you sign it.
ma'am.
And after you sign it, we'll get you sworn in if you still want to enter a plea. All right, thank you. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Thank you, sir. All right, so, Mr. Mickens, did you understand the rights on your plea form? The one you just signed, have you seen it?
Yes, ma'am.
Okay, so you know that nobody will have to prove beyond a reasonable doubt to a jury that you had the beer, and the jury would have to be unanimous in their belief that the state proved it before you could have this on your record with a withhold of adjudication. You understand that?
Yes, ma'am.
Is it easier for you to finish it today than to come back to court?
Yes, ma'am.
Okay. And if you were on probation, this would violate your probation. If you're not an American citizen, it would result in deportation. You understand that?
Yes, ma'am.
All right. It appears that you are alert, intelligent, making a practical decision to plead out to a withhold of adjudication and time served. And so I will accept your pleas freely and voluntarily entered, find a factual basis, withhold adjudication on the charge of possession of open containers, sentence you to the, is it 2 days, time served? Release you as of this charge. We do impose the court costs, which are something around $300-something. Give you a year to pay that if you're trying to make partial payments, because when you fall behind on your criminal court cases, we suspend your license in Florida. And I think the agreement is to take no action on the possession of methamphetamine resisting tampering physical evidence charge. I'm not seeing your return date on that, but you need to check and make sure you get back to court at the appropriate time. You probably know you could have been no bonded on the felony for getting a new charge, so don't take it for granted that you can get any more criminal charges while you're out on bond, okay? All right, good luck to you, sir. Okay. Okay. Is this Ms. Reyes?
Yes, Your Honor.
Okay, we have case number 21MO603, Division 80. You can get a public defender if you want. The allegation is disorderly conduct and violation of state misdemeanor.
Yes, Your Honor, and the offer is a withhold of adjudication, credit time served. And I did speak to Ms. Reyes. She understands all the rights she would be given up and would like to resolve the case today.
All right, I'm sorry, I forgot whether you said withhold or adjudication again.
It's a withhold, Your Honor.
Thank you. All right, and she's out on bond, but for a felony. But it appears that some of these, when they're resolving Ms. Reyes, they're not trying to adjust your bond. It is a violation of release conditions to get a new charge while you're out on bond. And you oftentimes face no bonding on that, but I think things are getting a little bit more fluid more recently on keeping people in jail for that. All right, if you wish to resolve the case with time served and not a technical conviction, go ahead and make sure you read the plea form. After you've read it and understand it, you can sign it. Thank you. Would you raise your right hand to be sworn in, ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Okay, so the disorderly is about fighting, I guess. And I guess the state misdemeanor might be sort of a kind of resisting, but they just called it state misdemeanor, which is going to be a little ambiguous on your criminal history, but that's supposedly what it is. They, and I think that was about not stopping fast enough when they told you to stop fighting. You don't have to say anything, but it's time served anyway. We try to get people to not confess even when they're pleading out. Anyway, so and you're only 19, do you understand all the rights on your plea form?
Yes, ma'am.
You're starting to clutter up your record a little bit. Any questions about that?
No, ma'am.
Because people can find it. They can just look on the clerk's website and see all this. All right. You're giving up the right to have a trial to see what a jury would do with this if they heard all the testimony and evidence and, you know, supposedly the officers testifying about seeing two females fighting and, you know, whether or not who started it or who was defending who or whatever. You're just basically pleading out to fighting, basically, after the bar's closed. And they won't have to prove it beyond a reasonable doubt to a jury of 6 people. Understood?
Ma'am.
Any questions about your rights on the plea form?
No, ma'am.
You won't have a defense about she started it, or I was just defending myself, or any of that stuff. Understood?
Yes, ma'am.
Okay. And you're not under the influence of anything now?
No, ma'am.
Okay. If you were on probation, this would violate your probation. If you're not an American citizen, it could result in deportation. Understood?
Yes, ma'am.
All right. It appears that you are alert and intelligent, entering a plea of no contest in a free and voluntary manner. There's factor basis to justify the plea. So accept your plea of no contest, withhold adjudication on the count of disorderly, count 1, and state misdemeanor, count 2, giving you credit for, I think, 2 days, time served, and release you as to these charges, take a no action on the felony that you're out on bond for. Make sure you come back for your court dates on that one. Meantime, we applied the court costs of a little more than $300 to the one that you just pled out on, but we give you a year to pay in case you want to make partial payments on that. If you don't pay, then we suspend your license until you pay. All right?
Thank you.
Good luck. Yeah, that was a withhold on both. Yeah, thanks for asking. Okay.
Can we do the Portuguese? Okay. Okay.
Are you okay?
No, I'm fine.
Um, So Kesem, oh, wait a minute, we're just going in actual alphabetical order. Did we do something with Kesem Moros?
That's the Portuguese interpreter that we're gonna.
Oh, okay, okay. Thanks. Is this Ms. Brooks?
Yes, ma'am.
Okay, thank you. She filled out a PD form, okay. All right, Ms. Brooks, it's case number 21 CF 6037. Let's appoint the public defender for you. Counsel, it's going to Division 10. And it appears they had enough information to at least file the charge of child abuse, given all the circumstances and conditions. No history. I guess the charge itself just doesn't qualify for the PTR. So the bond would be 1,000.
Sorry, Your Honor.
No, I wasn't sighing because of that. I was sighing because I'm a little tired. But ma'am, despite your lack of criminal history, I think this one is going to require a $1,000 bond.
Your Honor, state would also request no contact with the victims or witnesses.
Oh, okay. Let's say except pursuant to the Department of Children and Family Services and juvenile court orders. So if they say, they'll say what the conditions are. In this case, we'll follow that.
Yes,
Right.
I don't believe it was. Okay.
It was the conditions of the room and all that, and they're gonna, maybe put you on a parenting plan and stuff. Yeah, thanks. Yeah, comply with DCF and juvenile court orders. All right. Mr. Cardenas?
Yes, ma'am.
Sir? Correct, I think. Well, that's the other one. Right?
Sorry?
Okay. All right, sir, this is case number 2019 CF 15918, Division 16. And it was an alleged failure to appear on an old petty theft case with 2 prior convictions, so it was in felony court. And that judge set it at no bond, which is what they do sometimes on the failures to appear. You evidently had a status hearing July of last year, so you'll need to go back to that judge. But I think you already had the public defender on that.
Yes, ma'am, I do.
All right, so when you get back to court, you'll have your lawyer there if you don't see him before. That's it. Okay. Welcome. I'm getting hot under this mask and everything. It used to freeze in here. Is this Mr. Dameron?
Yes, ma'am.
Okay. Sir, this is case number 21 CF 6059, Division 20. And let's see about pointing did you fill out a public defender form? Probably want one just in case. If you're thinking about getting a private attorney, we'll start with a public defender just to get the case started. Looking at your history now. Okay, the out-of-state history is about the same. They had enough information to file this charge. Do you want me to skip reading the name of it? Can you hear me?
No, ma'am.
So,
Half in this year and half in this year.
all right, do you know where the judge is? Let me wave. The judge is over here. I know there's a lot of people in here.
Right.
He's going to give you some earphones to see if it helps.
All right, ma'am.
Okay, can you hear me now?
Nothing.
No. Testing, can you hear? Very good, thank you, sir. All right, so, sir, they have enough information to file the charge, and if you want, I'll skip reading the name of the charge.
Yes.
Okay, and the general bond on that is $5,000. I did wonder if you want, normally, we would appoint the public defender at the beginning, even if you did not fill out a public defender form. If you get a private attorney, that lawyer will just substitute for the public defender. Okay, that way all the paperwork can get started. And if you bond out, make sure you come back to court for all your court dates.
Your Honor.
No contact with the alleged victim.
Or minor children under the age of 18.
Or kids under the age of 18 while you're out on bond.
And you say the bond at 5,000, Your Honor?
Yeah, okay. All right, good luck, sir.
I don't know if he has any reporting requirements, because I believe he is a sex offender out of,
That's a good question.
out of another state, Ohio.
Well, his last conviction there was possession of drugs, so it looks like arrest, but not necessarily conviction, although he does have a fugitive from justice warrant, now that I'm looking more carefully. Maybe out of Ohio, so he's planning on moving to Florida, just like everybody else from Ohio. Oh yeah, he is a registered. Is it a requirement that we tell him to report it, or is that something we do to help him remember?
I think he should already be aware of his reporting requirements. I don't know if the court is required to tell him.
Yeah, we generally do. We didn't actually see, he's probably got a reporting requirement in Ohio. Can you all tell him that? Can we put it on his paperwork?
They can bring it.
Okay. Can we put it on his paperwork to remember to report this arrest to the Ohio authorities? Okay, which he probably won't anyway, because he's got a fugitive warrant evidently. We've got people doing three things at one time. Mr. Duarte? Okay. All right, sir, we have case number 21 CF 6019AO. It's going to Division 15, and we generally recommend you get the public defender. I didn't see an application form, but did you have one, counsel? Oh, he's. You fill it out? Well, we'll probably find it. Let's go ahead and appoint the public defender then. It appeared that there was enough information for the possession of methamphetamine charge to be filed, but he meets the PTR requirements. We'll find PC for possession of methamphetamine and paraphernalia. Sir, yeah, pretrial release evidently is available, not?
One moment, Your Honor. I believe they qualified him for PTR before he bonded out by quick release bail bonds, but unfortunately, quick release bail bonds endorsed his bonds.
Well, maybe they did that after they found out he qualifies for pretrial release, and they didn't want to block him from getting that. Right.
I don't know.
So we're trying to figure out what happened with the bondsman. Okay.
Saying something's wrong, something went wrong with him trying to bond.
So you were trying to bond out, and I'm just going to have to guess on this, but I'm pretty decent at the guessing, because I've seen stuff before. I'm guessing, as long as he's qualifies for pretrial release otherwise, does he? I mean, it's on the paperwork.
Yeah, he does.
I'm guessing that what happened was the bondsman realized you qualify for pretrial release, so they didn't want to take your money, so they came off the bond after you bonded. And as far as I can tell, there's no other obstruction. Okay, so we'll let you bond, or not bond out, but get out pretrial release without having to post bond. You'll have court dates and a public defender appointed.
State would ask for no drugs or alcohol without a valid prescription.
And the state always asks for no drugs or alcohol without prescription. And the PTR officer might be looking out for that, so. Good luck. Okay. All right, I'm somewhat used to you all going through them anyway. He does have a public defender form, appears to qualify. It's case number 2002-1 CF 6052, going to Division 15 Council. And it appeared they had enough information to file the charge of possession of cocaine, 0.2 grams. Bond amount 1,000. He was out on bond for aggravated assault with a firearm, possession of methamphetamine, possession of controlled substance. Total bond amount was $5,800 on that in Division 12. And I think he's got a public defender on that also. I don't know what the individual amounts were on those bonds. I've got the consolidated amount. If I was to double it, State, do you happen to know what the individual?
What it looks like was the possession of meth was 150 and the possession of a controlled substance was 150. So I'm thinking the other two charges added up to that 50.
So, well, there was
I think they're-
one charge of ag assault with a firearm, so you think that was,
There were two charges of ag assault with a firearm, Your Honor.
oh, so they were 2,500 each. Okay, they're down here, it has, them listed as one, so I get it. If there's two of them, they were 2,500 apiece, okay.
No, it was, what I'm seeing in IMS, one aggravated assault was at 5,000, the other one was at 500. And possession of meth, 150, possession of controlled substance, 150.
So to double count one would be.
Okay. Just double count one?
No, I mean, whatever you want to do, Your Honor.
Well, it's just like 0.2 grams of cocaine, so not,
Your Honor,
too worried about it. Huh?
That's the argument that I would make. It's 0.2 grams, not a huge amount. So I'd ask that you take that into consideration. If we double the $5,000 bond, that's $10,000.
I would just make the argument, he was out on a violent felony when he picked up, and drug charges, and he picked up new additional drug charges.
Right. He's got a little history, counsel. 5 felonies. And he's been arrested, and there's some serious, some violent stuff in there, even as a juvenile. So, I understand the point. I'll just double count one then.
So 10,000.
Yeah, and just
500,
say the other ones
150,
as they are, and, hopefully y'all can get them in court and figure out what needs to happen.
And you're gonna stay the possession at 1,000?
Yeah, the one that's, the new one?
Yes, Your Honor.
Yes. Okay.
Are we setting them at 500?
Just leaving them, yeah, well, the only one I'm doubling is count one.
Okay, so we're only addressing count one.
Right. Okay. Yeah. Okay. So this is Mr. Kazimuro. Oh, that's right. This one here? Oh, you got a different one. Teleconference? Yeah. Okay. I was calling the other interpreter.
I'm sorry, I cannot hear anybody. Hello?
Can you hear us now?
Now I can, yes.
Now, okay, sorry. Thank you very much. We have Mr. Kazimuro. Does he need the earphones, or are we doing it over the intercom? This is a Portuguese interpreter.
I'm the Portuguese interpreter. I'm doing this over the phone.
Okay, thanks. All right, so, we have some cases, including one in Orange County, which is 2020 CF 13213AO.
I'm sorry, interpreter doesn't understand what's going on. Can you clarify, please?
Yes, I read the case number. Did you need that?
Yeah, give me the number again, please.
Okay, 2020, capital C, capital F, 013213, capital A, capital O.
I think I missed the number. It's 20, and then there is a number, and then there's another 0.
2020 as in the year 2020.
Oh, I see. Okay. And then capital C is in Charlie, capital F is in Frank, 013213, A is in Apple, O is in Oliver.
Correct.
Okay. And how can I help you?
Well, we're just asking you to interpret it for the young man who is here for first appearances, and he has several charges.
Oh, I see. I didn't know what was going on, so thanks for clarifying for me. Alô, boa tarde, eu sou intérprete de português. Estou informando que o caso no Condado de Orange é 2020, C de Carlos, F de Francisco, 01323, A de Antônio, O de Olavo. Yes, go ahead, please.
Okay. So we'll appoint the public defender to represent you on the Orange County charge, sir.
Your Honor.
Ok, nós vamos escolher defensor público para ajudar o senhor no seu caso no Condado de Orange.
Given that this is a punishable by life offense, state asks that you hold him no bond pending an Arthur hearing.
Okay.
I'm sorry.
So the state's asking for no bond because these are punishable by life imprisonment.
Ok, esses ofensas contra o senhor não dão direito à fiança porque são punidos pela lei porque por prisão porque são ofensas do governo, são ofensas gerais.
So, sir, we're going to appoint the public defender. I realize you didn't have an application form in Portuguese. We're just going to appoint a public defender and assume that you qualify for their services.
Ok, nós vamos escolher para o senhor um defensor público. O senhor não tinha o formulário escrito em português e nós vamos então dar para o senhor um defensor público.
So, I read the police report in regard to the one in Orange County, and the allegation is that these things happened basically around August 20th of last year.
Eu li as informações da polícia sobre as alegações no condado que aconteceram em agosto de 2020.
And the allegations were, we had actually 3 cases. They happened around the same time. But in the Orange County case, it was at some 7-Eleven that a bunch of guys came in and held a clerk at gunpoint. 3 guys had guns, rushed the counter, got $300.
One second, please. We have to go slowly because there's a lot of information. Ok, são 3 casos que aconteceram ao mesmo tempo. Um foi no 7-Eleven, entraram de armas e tiraram $300 da caixa.
So,
okay.
Did you get most of it?
Yes, I did. Yeah, they got into 7-Eleven and at gunpoint, and they took out $300 from the store.
Right. And so supposedly it's on video, and there were some confessions.
There are some what? I'm sorry.
Supposedly it's on video.
Supostamente esse ato está em vídeo.
And so for the Orange County case, I would find that the presumption is sufficiently fulfilled to hold you no bond until you have another hearing in front of the judge.
Então, os acontecimentos do condado de Orange nos dão pressuposto que o senhor terá que ficar preso aqui até ser visto pelo juiz.
And we have 2 cases from the...
Your Honor, I believe there's 3 additional cases, but in regards to that case, they would ask for no contact with the victims or witnesses.
No
or
contact
co-defendants.
with the victims or witnesses.
I'm sorry.
So, taking the Orange County case first, we would require no contact with the victim, the store clerk, or any other witnesses.
Vamos dizer, no contact or no context. No contact with the victim.
Right, don't contact them or call them or talk to them.
Não entre em contato com a vítima. Nós estamos ordenando para não entrar em contato com a vítima, ok?
All right, and there are 3 cases in Osceola County which were reportedly similar.
Temos 3 casos no condado de Osceola que são parecidos.
Case number 20 CF 2741.
I'm sorry, 20 CF
2741. These are the case numbers.
3741. You said 3741.
2741.
Oh, 2741, okay.
And there's also 2745
Ok.
and 2748.
Ok, temos 3 casos. 20CF2741, 2745 e 2748.
These were the subject of the probable cause warrants by the other judges who also set no bond on these.
Esse caso também não foram designados que não aceitam fiança.
Actually, one of them is an attempted home invasion, robbery, and burglary of a
É tentativa de invasão e roubo de uma casa.
Your Honor, given all three additional case numbers are punishable life offenses, being robbery with firearm, attempted home invasion with robbery with a firearm, burg dwelling with an assault or battery therein, and additional robberies with firearms and criminal mischief with damage over 1,000. Since they're all punishable life offenses, state's asking that you hold him no bond on the three other Osceola cases.
Nos 3 casos do condado de Osceola, estão pedindo que não aceite fiança, porque todos eles foram com assalto com arma.
Well, I think it's sufficient to say that these are substantial, sir, and you're at no bond right now, and just let the attorneys work on the cases.
É para avisar o senhor que não tem fiança dessa vez, eu vou deixar os advogados trabalharem nesse caso.
And in regard to each of these charges, the state will be asking for a requirement that you not talk to the victims or witnesses.
E o Estado, então, vai pedir que o senhor, em todos esses casos, que não fale com as vítimas, não tenha nenhum contato com eles.
Your Honor, as to 20 CF 2748, count 3 is the only charge that he is entitled to a bond on. It is the criminal mischief with damage of 1,000 or more. So state would ask that you set a reasonable bond on that count.
I'm sorry, it's not clear.
Oh, that he's entitled to a bond on the criminal mischief charge on one of the other county cases. And so.
Okay, so you say that 2748, he's entitled to a bond. Is that what it is?
On one out of the 3 charges. So there's one charge that he gets a bond of 150, and it's the criminal mischief. Not 3.
Ok, tem caso desses 3 que o senhor tem direito a uma fiança de 150.
Okay. Good luck to you, sir.
Your Honor,
Boa sorte, senhor.
did you set a bond?
Is there anything interpreter can assist you with?
All right, thank you very much, Madam Interpreter.
Thank you for your service, Your Honor. Have a wonderful afternoon. Bye-bye.
Okay, thank you.
Oh, jeez.
Let's see, over here. Good afternoon. The next paperwork I have is for Kedrick Jackson.
Killinger?
He bonded, okay. Oh, I see that now, thank you. I'm not looking at the tabs very well. Then we're looking for an Eric Killinger.
Killinger's who bonded, Your Honor.
Killinger bonded also?
Killinger's who, I don't have a Jackson
I
either.
don't have that one.
Jackson bonded. I'm sorry. I still had the paperwork and didn't notice the tab that said bonded.
What's the booking number, you?
210-122-12.
On it.
Thank you.
You're welcome.
Well, I'm having a hard time recognizing people with a mask on, but is this Eric Killinger?
No.
No, my name's
Killinger
Sierra LeGrand.
bonded.
All right,
Eric Killinger?
we have multiple people bonding and not everybody knows at the same time. Thanks. You didn't look like an Eric, I'm sorry. All right, is this Sierra LeGrand?
Yes,
Okay, sorry for the confusion.
it's okay.
All right, ma'am, this is case number 2021 CF6050, and we can appoint the public defender to represent you. The allegation is battery on a law enforcement officer. It doesn't appear that you qualify for pretrial release, although it doesn't look like much of any history. It might be the charge itself that keeps her from getting PTR, would be my guess.
Did you get the updated? She hasn't.
Oh, is that the update? Sorry. The update over here. Thank you. Still doesn't say qualifies for PTR, but it does indicate some criminal history. Okay. Thank you. So, okay. Okay, it appears they have enough information to at least file that charge, ma'am, and the bond. They got the bond, they doubled the bond because her address might be out of state. Currently attending college?
Yes, Your Honor, she's, my client's about to graduate, so I asked that, she be allowed to return to Pittsburgh.
Wow. You sure have an interesting history. Right, hold on a second. Supposedly fighting, which, at the Senior Frogs Bar, which is evidently consistent with her criminal history, even though she's going to college. You might want to decide which path you're going to take. Looks like two different people here on paper.
Your Honor, my client is a student, as you can see on the paper. I would just ask that because she lives out of state.
Could you speak over the paperwork that's really loud in my ear?
Sorry.
Thank you.
Because she lives out of state, I believe that it's going to be harder for her to post the bond through a bail bondsman. So I ask that you consider that and lower the $5,000 bond. She's a student, she's getting ready to graduate, but $5,000 is too high for her to afford.
Let me just look and see how bad this was. I'm just like having a lot of cognitive dissonance over her. She seems to have an anger management problem.
Yes, Your
She's
Honor.
also trying to do something with her life.
Yes, Your
But
Honor.
no, main thing is that we get her back to court, because if she doesn't, she'll have a warrant out and she won't be able to do anything with her career because she'll have a warrant here, but that gives her additional reason to come back. Let's see, she's so supposedly fighting at Senior Frogs, trying to arrest her, tensing the body, kicking her with the right foot, and then laying across the seat so he couldn't close the door. He assisted in sitting her upright. Okay, so she potentially kicked him in the leg. All right. 24. Well, all right. Look, we normally double them to give the bondsman the ability to get on a plane and go get you if you don't come back. I will lower it to 3,000, giving the bondsman some backup if they have to get on a plane. Recognizing, I'm glad you're in college, but I do think you need to check out your anger management issue. And make sure you come back to court, or we will have a lovely warrant for you, which is going to mess up your career plans. Good luck. You're welcome. Is this Mr. Mixon? No. Did he bond?
We have Martinez next, Your Honor.
This one that was pulled out of order.
Oh, okay. Mixon, okay, good. That one, he bonded. All right, so this one is Mr. Martinez, and he might qualify for pretrial release in regard to case number 2002-1 CF 6044, Division 12. I don't have a public defender application, sir, but you did fill one out? Wait, okay, it's here. You qualify for the public defender. Okay. Look at this real quickly. Motorcycle. Okay.
Your Honor, I would just ask for pretrial release.
State has no objection, Your Honor.
All right, if they have no objection, I'll go along with it, although it looks like, okay, no motorcycle endorsement. Fleeing the traffic stop. Tell you to register vehicle, okay, well. All right, we'll go along with that, sir. I'm not quite used to that in terms of fleeing and attempting to elude, but that appears to be the new methodology in regard to this kind of case. There might be some other citations out there that you got a notice for, which would end up in traffic court, but this one is currently in felony court. So we'll appoint the public defender, give you a court date, and watch out for the misdemeanor traffic cases, because that can get confusing when you have different court dates. But if you don't show up, then you get a warrant for your arrest for failure to appear. If you ever get get them mixed up, because there's like several, keep track with them on the clerk's website. You can look up your case under your name. So you keep your court dates straight. Oh, it's a PTR. Thanks. But the traffic cases didn't come in with it, so make sure you go to court on those when you get your paperwork. Okay, is this Mr. Murray? All right, sir. We have case number 2021 CF 601380. And you qualify for the public defender.
And Your Honor, he does qualify for pretrial release, given that it's a traffic violation, driving while license suspended, or revoked.
Wait.
This is Mr. Murray.
Carrying concealed
sorry.
firearm, possession of
Wrong
cannabis.
person. I'm sorry.
Okay. It's going to Division 14. I feel you, it's a lot of paperwork, and there comes a point where your eyes start to cross. All right, and he's out on bond for battery and resisting without. But he bonded back in August. Wait a minute, it's now a misdemeanor, that other one. 2020 MM 5776. All right, sir, let's appoint the public defender, and it's taken me a second because I took too long on one case. I have to read at this point. Concealed firearm and possession of cannabis. Failure to use signal. Yeah, the suspected cologne, he knows that people wear cologne to camouflage the smell of cannabis. So he gets more OPD units. Wow. But another officer smelled the cannabis. It's amazing. And they found what they thought was a leaf. And so then they started to search everybody. Okay. Okay, well, so, sir, At this point, they have enough information to charge you with carrying concealed firearm, possession of cannabis. I'm just looking at your criminal history. Not a whole lot. You would have otherwise qualified for pretrial release except for you were out on bond. All right. A little bit concerned about what the lawyer's going to do with some of that. But, you know, the smell of cannabis seems to emanate from everywhere. It's just remarkable how that happens. But you don't appear to be, I mean, we worry about people with guns. We worry a lot about that because there's too many people getting shot. But I don't sense that you're an immediate threat. So I won't revoke you on the other charge. I'll just take no action. And it's partly out of concern about what, you know, you guys are going to do with the new case. But I'll leave the bond at the bond amount. They have probable cause. You might just have some other legal issues there. $2,500 on the carrying concealed firearm, $100 on the cannabis, appoint the public defender, make all your court dates. Now you might have two different judges unless your lawyers get it more conveniently put. I think, are you on pretrial diversion on that first case?
Yes, Your Honor, he was referred to diversion.
Oh, okay. So let's, they'll probably submit some paperwork and try to kick you off pretrial diversion, but maybe, I don't know. I don't know if that will hit before you bond out on the new charge.
Your Honor, state would request no weapons, firearms, or ammunition without a concealed weapon permit and no drugs or alcohol without a prescription.
Did you hear all that? She always asks for when you have a drug and or a weapon charge, for you not to have any more of those while you're out on bond. Okay? Your lawyer doesn't want you to talk about the case. Did you have a question that was not about the case? Okay. Did Novellis Blake bond out? Not? Behavior. Okay. So that was 21 CF 6046, Division 20. Let's appoint the public defender.
I'll waive the appearance, Your Honor.
Thanks. Finding a tampering with physical evidence charge, probable cause, stay in the bond at 1,000. And he's out on bond for driving with license suspended. That was transferred to a traffic court. That he's had going on for a little while. I think he's probably working on his license. State going to worry too much if I don't bother him on that and just let him bond out on the new one?
Your Honor, he also has another case.
Does he have
Possession of
more than
cocaine.
one that he's out, or he has another new case?
New case, possession of cocaine and the tampering.
Oh, so they just separated it into two different, okay, two different. All right, so one's 21 CF 6045.
And Your Honor, he is currently working on getting his license from the notes that I see in our system.
All right, well, let's just find PC on, both of them. And we'll find PC and do the 1,000 on the tampering and then 150 on the cocaine, because I think that's what would happen if they were in the same police report. And I'm going to leave him alone on the Dwellis because he's probably working on it.
And Your Honor, state would request no drugs or alcohol.
No drugs or alcohol that are not prescribed while out on bond. Thanks. Is this Miss Ortiz? Thank you. Okay, The case number is 21 CF 6025. Let's appoint the public defender to represent you, ma'am. Thank you for trying to keep up. Ma'am, and this is going to Division 12 Council. The allegation is possession of methamphetamine. Look. Okay. I guess they just charged everybody with it. I'm not clear where that meth was and where it's closer to her than somebody else.
Because when I was
You don't have to say anything about the case.
Your Honor, I was sitting on the driver's seat, and Miss Ortiz was arguably the driver.
She was driving?
Yes.
All right, I'll find probable cause for possession of methamphetamine, bond amount 1,000. And the other ones, it says, no voter vehicle registration. Take no action on that. Ma'am, just, now you have a couple cases pending. Make sure you keep up with all your court dates.
Your Honor, state would ask for no drugs or alcohol without a prescription and no contact with a co-defendant.
Okay, so ordered. Thank you. Mr. Oughton?
Yes.
Thank you, sir. We have case number 2021 CF 6041. We can appoint the public defender. It's going to Division 20. The allegation is possession of methamphetamine. The bond amount $1,000. And it appears they have enough information to file that. So we'll appoint the public defender and tell you to make sure you make all your court dates, sir.
No problem.
Your Honor, state would ask for no drugs without a valid prescription.
Okay, so ordered. Mr. Pickens? All right, sir, the new allegation is 2021 CF 6027. Public defender is appointed. Looks like a driving license suspended while allegedly on a 5-year revocation. They have enough information to file that. And you're out of bond for driving a license suspended.
Your Honor, that case is filed on, and the bond was 2,500. We ask that you revoke and double
What, the old one?
the out on bond.
I have the pretrial information sheet that the bond was 2,500. Did it later get lowered to 100?
No, Your Honor, that's what I said, 2,500.
2,500, I'm sorry, I can't hear anymore. All right. Okay, I think that, sir, the other judge would probably assume that I'm at least going to double it. It looks like you got some priors for that also. So let's set the bond on the new one at 2,500, double the old one to 5,000, so revoke and then double. And talk to your public defender. Is this Mr. Providence? Okay, sir. The case number is 21 CF 6028. It's going to Division 15 Counsel, and public defender can be appointed. The allegation is 2 counts of burglary of vehicle and petty theft is count 3. I do need to read it real quickly. Okay. Okay. Looks like they have enough information for 2 counts of burglary vehicle. Looking at criminal history, drugs, burglary. Okay. So, sir, the first bond is 3,500 on the count 1. The second one, our add-on charges is 150 for count 2 and 100 for count 1. Make sure you come back to court for all your court dates. Talk with your public defender beforehand.
You mean count 3?
Is that what I said?
You said 100 for count 1.
Okay, that's count.
Okay.
Count 3 is the petty
We said
theft at
3,500,
100,
don't you
count
think
2
we
is 150, and count 1 is 3,500 on the first one.
And his other case, Your Honor?
I thought it was 2 counts in 1 case. Okay, so.
There's 3 counts on 1 case.
2021 MM 3497, Division 62, a resisting. Pull over, and he didn't. Pull over and he ran. Okay, resisting charge, bond amount $500. Good luck. Yes?
On his Burr conveyance and petty theft case, state would ask for no return to the area and no contact with the victims or witnesses.
Okay, so ordered, thank you. Mr. Rivera is next, I believe, which is 21 CF 6029. Okay. Can't hear. And he needs an interpreter? Okay, should we just call him up, folks? And I don't think he filled out a public defender form, or maybe it might be around somewhere. Didn't see, okay. All right, so, We ready to call the interpreter? Yes. Okay.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you so much. We have one case here, a Mr. Henry Rivera, case number 2021 CF 6029. And we're going to appoint the public defender. We don't have a public defender form, but we think it's appropriate. The allegation is grand theft with a bond amount of $500. It appears that they have enough information to file the charge. If he bonds out, let's make sure he comes back to court for his court hearings and talk to the public defender beforehand.
Your Honor, state would ask for no contact with victims or witnesses and no return to the area.
Okay, so ordered. Thank you. And that's all for now, sir. If you bond out, come back to court for all your court dates. Thank you very much, Madam Interpreter.
Thank you, Your Honor.
Yeah, thank you. Thank you. Okay.
Good afternoon.
Good afternoon. Did Adrian? Okay, thank you. Then this is Anna Sears. She filled out a public defender form. I remember a co-defendant, or this was an add-on?
Yes,
Yes, Your
add-on.
From the carjacking cases last week,
From,
the double
was it last
carjacking.
week?
Yes, Your Honor.
All right, this one is 2002-1 CF 6051, Division 10, a grand theft motor vehicle charge allegedly from May 17th. And I think they're just adding one on. So let's go ahead and find probable cause on that, appoint the public defender, stay the bond at 1,000. It's just an additional charge.
Your Honor, state would ask for no contact.
No contact with the alleged victims or return to the scene. Oh, we know that you're in jail anyway. All right. Is this Mr. Seraphin Pierre?
Yes, ma'am.
Thank you, sir. We have case number 2002-1 CF 6039 in Division 19. I don't have a public defender form, but we probably will appoint them anyway, just to get your case started. Are you intending to get a private attorney? Okay, just have them substitute in for the PD. Okay. All right, they have enough information to at least file the charge of the possession of a firearm. Carrying concealed firearm with the bond amount of $2,500, count one, and grand theft third degree That'll be a subsidiary charge at 150 instead of 1,000. He was out on bond for grand theft motor vehicle. Since this seems to be a similar situation, it being a stolen vehicle, sir, the felony judge would probably assume I'm going to no bond you on the one that you're out on bond for, but I'm sure you have a public defender on that one in Division 10, and go back and, if the public defender thinks that they can get a better situation for you, they'll file a motion for you on that.
Your Honor, I would just ask that you double. I understand it's a similar in nature charge, but given the fact that other than those charges, he has no criminal history. So I would just ask that you consider doubling the bond as opposed to holding him at no bond.
I think that's going to be the judge's preference when it's the same thing, to be honest with you. All right. Thanks.
So you're revoking and leaving at no bond?
Yeah, when it's the same thing, kind of thing.
Your Honor, can you appoint, I don't believe we were appointed. I looked in our system, I couldn't see the out on bond.
Oh, let's
Could you
go ahead and
appoint us?
appoint the public defender then. Thanks. Did you get that?
Yes, sir.
All right, thanks. All right, is this Andrea Sharber? Okay, thank you. We have case number 2002-1CF-1511. That looks like a failure to appear warrant. Let's appoint the public defender if you were not previously appointed. In regard to that warrant, it was an alleged failure to appear on a resisting an officer with violence in Division 20, and that judge set the bond at $2,500. Then there's 2002-1MM-3508 in Division 62, an alleged possession of drug paraphernalia. From the 23rd of May to warrant search with no, they got probable cause for that. You guys you don't resolve the new misdemeanors when they come in on a felony?
Your Honor, since it's the underlying for the failure to appear, not at this time.
Was that a yes or a no?
Not at this time, Your Honor.
All right. Ma'am, so if you bond out, you got a misdemeanor also. But you had a failure to appear warrant and felony, so probably you'll need to go back and see that judge.
And the bond, Your Honor,
So on the new one or the old one?
on the possession?
That was a 500 on the possession of paraphernalia. All right, good luck, ma'am. Is this Mr. Sinrex? Okay. Sir, the allegation is 2002-1CF-6026. Let's appoint the public defender to represent you. Okay. This was, I hadn't read this one yet, but this was one where they charge him for every bullet again, maybe?
Yes, Your Honor.
Okay.
Each round can sustain its own charge.
Can't hear anything anymore. Oh, this is, I remember the co-defendant on this. Okay. What do the felony judges do on these where they want to give them a separate bond for every bullet?
Treat them as subsidiaries.
Sir, ma'am?
Treat them as subsidiaries.
Subsidiaries, okay. And so 4,000 is the current bond amount on the possession of firearm by convicted felon?
Yes, Your Honor.
Right. seeing the history, so, all right, so, sir, let's find probable cause, counsel, let's go into Division 17 and stay the bond at 4,000 on count one, the possession of the firearm. The other ones, where each of them is a bullet, counts 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. The separate bullets are just 150 apiece. That looks like a count 4 carrying concealed firearm. Probably the same gun, so it's another subsidiary charge. That will come in at 150 also.
Your Honor, state would ask for no weapons, firearms, or ammunition.
All right. No, see, there's one at the end, it's different. Count 14. Yeah, 14.
Okay, so count 2 through 14 is 150.
You're welcome, thank you.
Any conviction?
Yeah, don't possess any guns. Yeah, put any guns in the care of the law enforcement within 24 hours of your release. All right. Is this Mr. Henry?
Ronald Lewis Round.
I didn't hear his last name.
Round.
Ronald Round.
All right, so what about Soto Rosario? That was a move up. So we have Mr. Round?
Yes, ma'am.
Okay, thank you. Sir, this looks like a warrant from Marion County on a driving with license suspended. They have it at no bond, sir. Case, it's a 2019 felony, driving with license suspended. Probably a failure to appear on that. So Marion County will come pick you up on that. And that's all we have for you today. So that's it? We don't have the 33-day motions, or did we already do those today?
We did this morning, Your
All
Honor.
right, it's all kind of flowing through. Thank you all. We'll be adjourned then.